All right. Welcome to Magna Carta 2023. Let me take a quick understanding of what the demographics of the class are. How many of you are writing the exam for the very first time? For the very first time, a couple of first attempters. Okay. The rest of you are veterans? Good. Okay. You're here because you've seen me on a YouTube video and therefore you think I will change your life. Good. Magna Carta is a no-nonsense crash course for polity and governance. We have just one very simple target. 90% of your questions in the prelims exam for polity have to be correct. That is it. Not here to make you learn the law, not here to make you love the law, not here to make you feel intellectually superior. We have one very simple goal, and that goal is to get 90% of the polity questions right by hook or by crook. Are we clear on this? Yes? Good. Now, we're going to be covering 4 primary things in this course. 1, polity, governance, and IR. Right? Now, polity, of course, everybody is fairly okay with. Governance in the prelims exam is asked in simply 3 forms. 1, a possibility that you may be asked a question on a scheme. Second, a possibility that you may be asked a question on a regulatory body or a sector identification or some sector analysis in a certain way, which has been in the news. And 3 would be a report or an organizational report about a sector in the country. IR has the following questions in the prelims exam. 1, you may get questions which are interlinked with geography, hotspots because of issues or events that have been in the news. 2, international organizations, and 3, reports by international organizations. We'll cover all of this in this set of series. Second, this is a government exam. This is a Sarkari exam, has to be prepared in a Sarkari manner, which means we only have 2 things that we can blindly trust: the syllabus and past year papers. Now, because the syllabus for the prelims exam is an apology of a syllabus, it just randomly mentions 5-6 words. So we are heavily focused on deducing or figuring out or predicting questions based on past year papers. Nothing is complete without past year papers. Third, after every substantial coverage in class itself, I will teach you some hand gestures and we will solve the questions here in the class itself. And towards the end of the series, I'll give you a sectional test which you will attempt right after class here in itself, right? And fourth, you will get these kind of lecture notes in a flashcard format. Remember, in so many ways, our beloved Lakshmikant is factually incorrect. I will be making a lot of statements in class which will directly contradict what is written in Lakshmikant. But I am right. For example, heard of the Public Accounts Committee? Comprises of Lok Sabha and Rajya Sabha members? No. It is primarily a Lok Sabha committee. Even if Rajya Sabha members are not there on the Public Accounts Committee, it still functions perfectly well. So, whenever there is a factual inaccuracy with Lakshmikant, I will flag it there and then. Clear? This is also one of the reasons why they never ask you compositions in the prelims exam, because committees are procedurally very diversified. Every house has their own committee frame. Clear on this? Understood? Yes? For example, privileges. The house decides, not the speaker, not the committee. The house decides. So these are some red flags which we'll keep correcting. So that is why these lecture notes become very, very important. Okay? So let's begin. This is your schedule. We have about 12 lectures, 2 lectures per day, 11:30 to 1:30. Give you a half an hour break, have your tea, coffee, lunch. We reconvene at 2 o'clock sharp, 2 to 4, we finish it. 6 days, this should be done and you're ready to write the prelims exam. Now, the syllabus, as we understand it to be, headlines as Indian polity and governance. We understand that polity is the study of the framework of a country. It's not just the law. It is the entire ecosystem in which the state functions. The legislature, the executive, the judiciary, the institutions, the study of civic society, all of it is under a larger umbrella called polity. Now, your prelim syllabus identifies 5 key components. 1, constitution. 2, the political system, which is why you will often see in the prelims exam questions which say with reference to the constitution, as per the constitution, according to the constitution, because it's clearly established. 3rd, Panchayati Raj. Very rarely will you see a prelims question on urban local government. You will see 90% of your prelims questions on rural local government because it has been clearly identified in your syllabus. At least in the last 10 years, you will see next to 0 questions. Then public policy. Now this is again a googly, because public policy is simply governance, social justice, macroeconomics combined. Public policy is the study of problems and solutions. So for instance, let us say uplifting the transgender community is our policy problem. We can solve this in multiple ways. 1, make a law for them. 2, make an institution for them. 3, make a scheme for them. 4, do all of the 3 things together. That is public policy. And that gets asked in the exam, which is why in the prelims past year questions, you would have seen which of the following facilities are available for transgenders, or legal aid is available for which of the following vulnerable section communities. Because vulnerable sections is one of the primary ingredients of public policy. And then rights issues. A common conflict with rights issues is if the constitution has fundamental rights, has constitutional rights, then why does the prelims syllabus identify rights issues? You would remember in the last 2 years or so, there was a question which spoke about, is the right to city? Where does that question come from? It comes from urban rights. It comes from livelihood rights. So those kind of rights issue. We'll keep covering them as and when need be. All of this gets interlinked with current affairs for national and international importance. Let me cut straight through the chase. There's nothing called current affairs in polity. Something might be in news because of which the context would be asked in the prelims. For example, a national leader is facing disqualification. You would be asked the basics of disqualification, which is also true for the mains exam for most parts of it. Very rarely do you see current issues being picked up as current issues and placed in the prelims. This is true for other subjects, but we have an advantage with polity, which makes our life easier, which is why it is easy to get most questions right in polity. Ye clear hai? Is pure English okay? Would you like a little bit of Hindi in the middle? Pure English is perfectly fine, right? Good. Then, economic and social development, which is technically your economy syllabus, also has social sector initiative, right? It also has poverty, it has inclusion, sustainable development. We pick up the welfare schemes from there and we merge it with governance. Clear? So technically your prelim syllabus becomes polity, governance, social justice and social issues. These are your 4 key components that we're going to be covering over the next fairly intense 6 days, right? We'll start with 2 lectures today. The first lecture that we're doing right now is perhaps the most important lecture. You get this lecture right, everything else is simply fill in the blanks. In this lecture, we're going to be studying basic concepts and approach methods. Let's understand what it is. Right. We're going to be studying a total of 15 things over the next 2 hours. Let me tell you exactly what those 15 things are. These are the questions that have been asked from these 15 things. We will first start with approach and elimination methods. ज्ञान का time ही नहीं. We have to learn the tricks, the approach methods to get polity questions right. Orientation has to be rock solid, a tunnel vision. Question ऐसा है, इसमें ये ट्रिक लगेगा, ये ध्यान रखना है. We have to be careful of this. We can't get carried away with this. Our first topic is going to be approach and elimination methods. These are standard. There is a UPSC way of framing polity questions. For example, a few years ago, there was a question which was that who is the custodian of the Constitution of India? And the entire Rajinder Nagar was on fire, almost a riot, because the intellectuals said, sir, I have studied the oath of the president. I have memorized the oath of the president, and in the oath of the president has to defend the Constitution. I said, Idhara, what is meant by custodian? You're protecting something from someone. So you're protecting the Constitution from things that violate the Constitution. And who decides something of that nature? The Supreme Court. And that is your answer. Clear? Right to vote, right to contest and be elected. But sir, right to vote is an expression, sir. I am politically expressing myself. No. Supreme Court judgment, X is a statutory right, Y is a constitutional right. Khatam. Gyan chahiye hi nahi. Clear? So that. Now, what I've introduced this year as new topics are these. Because the UPSC has, over the last 5 years, started asking philosophical and jurisprudential questions in law. What is meant by constitutionalism? What is a constitutional government? What is rule of law? So just for about 5-10 minutes, at the end of the day, we are studying the law. We should know where law comes from. The basic sources of the law. Once we are done with this, we will do a larger framework of laws. What is international law? What is domestic law? What are the different kinds of laws that exist anywhere in the world with a special focus on India? After topic number 3, this is a new introduction for this year, I will teach you legal systems. Every country in the world follows a set legal system. Why do we say that UK, India, Australia, New Zealand have very similar legal systems, have very similar laws, have very similar structures? Because they follow a similar legal system. It's not watertight. India has taken a little bit from here, a little bit from there, a little bit from here. But dominantly, we are a legal system. You would have heard of common law. This is what we're talking about. Just to get our concepts right. Once we're done with this, we then move to rule of law. Now, the UPSC has asked applications and components, so we will go a step further. We'll do the definition, we'll do the components, we'll do applications, we will do exceptions to rule of law. And the second rule of law ends, principles of natural justice begins. Because rule of law is for the law. Tomorrow, when you are the collector and you have the discretionary power to decide X, there is no law. You are governed under a larger set of principles called administrative law. So how do I make sure that the famed enforcement directorate in our country is fair with its prosecution? Principles of natural justice. When Menka Gandhi's passport was taken away from her without giving a chance to her to express as to why are you doing this, without giving an explanation to her as to why are you doing this, it is not a violation of rule of law, it is a violation of principles of natural justice. Because the administrator, the regional passport officer, had the powers to do this. And this is a new detailed inclusion this year. We'll do components of principles of natural justice, we will do exceptions, we will do some modern principles as well, just in case they get asked in the exam. And then we will understand that at the end of the day, all that polity is keeping the government in control. We cannot let the people who govern us have relentlessly open-ended powers. So the idea of limiting the government is called constitutionalism. So here we go a step ahead. The UPSC is already asked, what is the constitutional government? For 3 years straight, they've asked, what is the constitutional government? What is the constitutional government? What is the constitutional government? So we will study constitutionalism, constitutional law, and constitutional constitution. Clear on this? Understood this? Yes? Now, from here, we will move to India's constitutional development timeline. Our journey begins from the Government of India Act of 1935. Till 2005, the UPSC used to play a little naughty. They would ask you questions on Montague-Chelmsford reforms. They would ask you questions on the Government of India Act of 1990. But 2005 onwards, if at all there is a historical context, it is with the Government of India Act of 1935. Clear? So that to the Constituent Assembly, to the framing of the Constitution, and we move on. This also overlaps with your modern history syllabus. So I will keep this as a buffer topic. Either do it today if you're not running out of time, or we do it the first thing tomorrow. Clear? Then we move to the legal nomenclature. Just about for 2 minutes, what is the Constitution framed like? Will not take more than that. This has no relevance for the prelims exam, but in the interest of humanity, I'd like you to read the Constitution properly. It hurts me in places you can't imagine. When kids come and tell me, sir, section 21A is right to education. Then, remember our polity prelim syllabus says political system. So we have to understand what is a political system. The difference between a democracy, a monarchy, and a dictatorship. The difference between a direct and an indirect democracy, and the different kinds of democratic institutions. Direct and indirect democracy and direct and indirect elections are two completely different things. We'll get our basics right. From here, we'll move to an entire layout of the Indian political system, right from the president to the Gram Nyayalaya. This will be slightly more refined than last year, but the structure remains the same. Topic 13 and 14, changed it completely this year. We'll study majorities. Again, some basic errors in Lakshmikant would be pointed out. For instance, the majority to remove majority to remove presiding officers is effective majority. It is not absolute majority. Special majority you've heard of, more than 2/3 of present and voting and half of total strength. This is actually done in 2 separate rounds of voting. Otherwise, what is the point? It's done in 2, the same house sits and votes twice. Clear? Because you need that double validation. Very clear cut, concise answers to questions. Once we are done with this, we move to a hierarchy of laws in the country. We apply the majorities to lawmaking. And we will apply this to the rest of our 6 days across 12 lectures. And we'll close with the famous golden rules on polity. Sorted? Clear? All right. Let's begin. Approach methods. Very important. First, a common mistake students often make. A few years ago, there was a question which said, according to the Constitution, judicial review is mentioned under what? Under nowhere. Judicial review is not mentioned anywhere. Even if Article 32 and 226 is screaming in your faces, judicial review, judicial review. Do the words judicial review find explicit mention in the Constitution? The answer is a no. Do the words federalism find explicit mention in the Constitution? The answer is a no. Rule of law? No. Principles of natural justice? No. Judicial activism? No. Judicial review? No. Nothing. A common mistake that students make. The first rule is understanding the UPSC language when you're solving polity questions. Now, understand there are 3-4 ways in which they formulate their questions. If the question says, according to the Constitution, as per the Constitution classifies ABC as, or ABC is mentioned in the Constitution, or the Constitution defines XYZ as. For example, last year there was a question that the Constitution classifies cabinet ministers as ABC. Constitution doesn't classify JAG. That is your key point. If you see the word according to the Constitution, as per the Constitution classifies, ABC is mentioned as XYZ, the Constitution defines XYZ, it means it has to be explicitly in black and white written in the Constitution. If the question says, as per the Constitution, due process of law is under Article 14, that is incorrect. Because due process of law is not written anywhere. Procedure established by law is under Article 21. Clear? It has to be expressly, explicitly, in black and white, in those words written in the option. It cannot be derived. It cannot be a Supreme Court interpretation either. Now remember, this applies to non-fundamental right questions. If the Supreme Court has interpreted that, or the Supreme Court has given a judgment that says an ordinance that, for example, questions of anti-defection law must be decided within 3 months. There's a Supreme Court judgment for it. No. Does it say so in the Constitution? No. Has it been expressly amended in the 10th schedule? No. So if you have a prelims question that says, according to the Constitution or as per the Constitution, anti-defection petitions must be disposed of within 3 months as per, no, not at all. Advice of Council of Ministers, Supreme Court interpretation, governor role, Supreme Court interpretation, nothing, zero, jack. It has to be expressly black and white. Clear? But fundamental rights, because they're derivatory in nature. So right to privacy is under Article 21. Is that correct? Yes. But that is where you stop. only preamble, part 3, 4, 4a. That is when you can give a little bit of a leeway. Clear? But nothing more. Understood? If I ask you a question, according to the Constitution, directive principles pose a limitation on the legislature. Is that correct? No. कहाँ लिखा है? कहीं नहीं लिखा है. The derivation has to be substantive. कि liberty के अंदर privacy. Understood this? Yes? Good. So what is okay? If you see the word under, XYZ is under this article, then you can take a leap of faith that privacy is under Article 21. Right to marry is under Article 21. That is okay. Under is okay if it says as per mentioned, no. And finally, everything else you can infer. Are we clear on this? This is your first rule. Let's apply this first rule to some real questions. Question number 20, this is the 12th question from that set, 2020. In India, separation of judiciary from the executive. Everybody can see this question? Is enjoined by. Enjoined is a formal word. Even if it is not written as per the Constitution, you have to find the most express mention. Preamble, DPSP, 7th schedule, conventional practice. Look for the most express mention. Is there a directive principle which talks about separation of powers? Yes or no? Bas, aage badho. There will be a little voice in your head that will say, but the preamble talks about democracy and republic and no, ganta, zero. Ye kaat dena bhai. Clear? Understood? Look at the next question. With reference to the Constitution of India, consider the following statements. No High Court shall have the jurisdiction to declare any central law to be constitutionally invalid. It basically means the High Courts cannot get into checking the validity of a law. Is it written anywhere in the Constitution? No. With reference? No. Otherwise also this statement will fail because of golden rules. But there you go. An amendment to the Constitution of India cannot be called into question. I will do a parallel distance masters from IGNOU. Hurry. Let's calm down. Let us see what is it that they're talking about. See. Option A community of persons permanently occupying a definite territory independent of external control, possessing an organized government. That is all that they're talking about. They're talking about territory, sovereignty, and government. That's it. What is the second option talking about? A politically organized people of a definite territory possessing an authority to govern them, to maintain law and order, to protect their natural rights and safeguard their means of sustenance, which is nothing but the authority. Everything after authority is just nonsense. Yes? All that it is generally talking about territory and sovereignty. The third option, a number of persons who've been living in a definite territory for a long time with their own culture and government. A society permanently living in a definite territory with a central authority, an executive responsible to the central authority, and an independent judiciary, which is nothing but explaining government. Yes? Option 1, territory, sovereignty, government. Option 2, territory and sovereignty. Option 3, territory, culture, government. Option 4, territory and government. Which is most appropriate? हो गया. Clear? Don't let complex questions scare you. Break it into smaller options. You can't afford to go wrong with polity questions. This is not an academically sound way to do it, but this is the way that gets us. आपको क्या चाहिए? Marks. हम क्या है? Marxist. With an S, not an X. Clear? Good. The next one is a slightly complex one, but if you get it right, you'll never go wrong. If polity is English, polity is also CSAT. You'll understand why and how is it CSAT. सवाल से सवाल करो, ठीक है? Polity is basic CSAT. Question the question. You will see a lot of these liberty questions. What is the most appropriate definition of liberty, which is an essential feature of parliamentary form of government? What does rule of law include? Question the question. So how do you question the question? In 5 ways. And one of these ways will definitely work 100%. One, does this option necessarily mean the statement in question? If liberty is the absence of, say, privileges, does that necessarily mean there is liberty? No. Not at all. किसी को स्पेशल ट्रीटमेंट नहीं दे रहा हूं, लेकिन किसी को कुछ भी नहीं दे रहा हूं, वो भी कहां लिबर्टी है? Does the statement necessarily help the question? ये हिट नहीं करे, ये क्लिक नहीं करे, if this doesn't work, look at the second one. Can the question exist without the option? Can parliamentary government exist without collective responsibility? No. The one thing you can't compromise with, the only non-negotiable in a parliamentary form of government, is collective responsibility. उसमें ऑप्शन में लिखा है which of the following are the striking features of parliamentary form of government. Option A says lower house is elected directly. Option B says the executive is collectively responsible to the legislature. Second is non-negotiable. Second is absolutely non-negotiable. And you can remove the first option by using the third statement. US also lower house is directly elected. US is not parliamentary. Hatao. What is absolutely essential? There was a question which again caused a lot of stir. Right to property. And right to property, whether it's available for citizens or non-citizens and everybody. Apply it in real life. If right to property was not available to foreigners, then how would you have foreign companies and foreign individuals owning infrastructure in India? Indians can buy property outside, outsiders can't buy. ऐसे क्यों? ठीक है, agriculture पे limitation लगा दो. Then how will you have multi-brand shops, international companies operating space in India? You will not. By a simple application of surroundings around you, you'll understand that right to property has to be available to not just citizens, but people who are also not citizens. Then, the devil's advocate. अगर ऐसा है तो ऐसा कैसे? अगर ऐसा है तो ऐसे कैसे हुआ? if lower house being elected is an essential feature of parliamentary system, then America should have been a parliamentary system. Nahi hai na? Get down to pure basics. And lastly, in usually these kind of derivative questions, the safest answer is always the right answer. यहाँ एक्सट्रीम नहीं जाना. When there is no law, there is no liberty. ये safe है. There is more laws, there is more liberty, not necessary. If all the laws are regressive, then you don't have liberty. But अगर कानून ही नहीं है तो सब रोक के बैठा है. Yes? याद रख. Apart from this, apply these two questions. See, there is a parliamentary system of government in India. 2015 question. Lok Sabha elected directly, Parliament can amend, Rajya Sabha cannot be dissolved, Council of Ministers is responsible. हो जाएगा? बिना Parliament पढ़े? Think about it. Just see how easy it is. Lok Sabha is directly elected. तो US किस लिए फिर? Parliament can amend. So in every country in the world which has a written constitution, and if their parliaments can amend, then they have to be parliamentary form. ऐसा तो नहीं है. Rajya Sabha cannot be dissolved. So, does this mean every parliamentary system has to be bicameral? No. और हमको करनी है dissolve. Parliamentary system करनी है. Does that make me any less of a parliament? No. Lastly, collective responsibility. यही तो फर्क हुआ. US president has nothing to do with the US Congress, which is collectively called the US Parliament. The US president has nothing to do with the US Congress, which is collectively called the US Parliament. The second our ministers lose majority, you're done. That is the feature of a parliamentary form of government. These are questions that most students after studying get wrong, because confuse हो जाते, प्रेशर होता है कि कुछ तो यूपीएससी हमारे खिलाफ षड्यंत्र कर रहा है. A parliamentary system is a system of government, or a parliamentary system of government is one in which all political parties are represented in the government. अरे जीता ही नहीं तो क्या करोगे? ठेठ बनो ना. Be as grassroots. ये सबको दी. ऐसे थोड़ी होता है. So this means when a political party in India gets 0 seats, India is not a parliamentary system. Congress. देखो मैं तो सेडिशन में जा ही रहा हूं. आपको क्या है? 2. The government is responsible to the parliament and can be removed by it. हाँ, तो 3rd, the government is elected by the people and can be removed by them. हमारे यहां हम निकालते तो कब के गए होते. Yes. 4th, the government is chosen by the parliament but cannot be removed by it before the completion of a fixed term. क्यों? तो नो कॉन्फिडेंस किससे रखा है? किसने रखा नो कॉन्फिडेंस? क्वेश्चन द क्वेश्चन कि अब तो सरकारी नौकरी है एमपी वाली. क्या बचा? क्वेश्चंस गलत नहीं, by hook or by crook, by whatever it takes. 3rd, ये rule of law. Which of the following are regarded as the main features of rule of law? It's a 2018 question. Limitation of powers, equality before law, people's responsibility to government, and liberty and civil rights. No matter how academically intense I might be to teach you rule of law, दिमाग में एक ही लाइन जाएगी, कानून का राज. मैं कितना भी ऐसे आत्मा ले आऊं एविडाइसी के अंदर, अंबेडकर बन जाऊं, but the only thing you will take home from rule of law is supremacy of the law. Now, if it is about supremacy of the law, see what doesn't fit. People's responsibility to government का सुप्रीमसी से क्या लेने देना भाई? कानून तो सरकार के लिए. And why do we have to be responsible to the government? The government has to be responsible to. सिर्फ इंग्लिश कॉम्प्रिहेंशन पे खेलो कि अब हमारी जिम्मेदारी है सरकार पे. क्या बोल रहे हो यार? क्या फूक के बनाया उन्होंने ऑप्शन? पीपल्स रिस्पॉन्सिबिलिटी टू द गवर्नमेंट. ऐसे थोड़ी होता है. हाँ. Which of the following reflects? ये देखो, ये यूपीएससी देखो, नाइसेस्ट. ये ऑफिशियल क्वेश्चन है, ये मैं नहीं लिखा अपने मन से, ये खुद लिख के दिया है इन्होंने. नाइसेस्ट. कौन लिखता है ऐसे? Which of the following reflects the nicest? उसके बाद लिखा भी है appropriate relation. Take the questions lightly. You cannot let them get to you. उसका अलग से पैसा लगेगा. If there are more laws, there is less liberty. Why? More laws can give you more liberty. ये तो जेएनयू वाली बात हो गई. कानून ही गलत है. अरे कौन सा? If there are no laws, there is no liberty. थोड़ा सा डाउट है. If there is liberty, laws have to be made by the people. Have you seen us? India's literacy rate when we got independent was 16%. If laws are changed too often, liberty is in danger. It is subjective. What is too often? क्या बचा एक ढंग का ऑप्शन? Even the most complicated questions, if done lightly, will always make sure that you have the right answers. Most people got this question wrong. In 2018, घर आ गए थे मारने मेरे को. सही नहीं पढ़ाया आपने. ठीक है, चले. Are we now okay? Remember, apart from this, there are of course some standard UPSC kind of what are called, वो जो standard होता है ना कि वो A and the ये सब नहीं करेंगे. ये बदलते कैसे हैं? Right. Apart from this, if an option has all, none, those are those extreme worded options. Before you are very sure, read the statement carefully. This applies across subjects. Similarly, if there is an option, if you have those multiple option choices, देखो कौन सा ऑप्शन है जो किसी में भी नहीं है. 3 में से एक जगह नहीं होगा. There are 4 options. One will be 1, 2, 3. Second will be 2, 3, 4. Third will be 3, 4, 5. Fourth will be 1, 2. देखो which is the least common. If 4 में से एक ऑप्शन में एक नहीं है तो एक एलिमिनेट कर, वही सही हुआ. बट ये हमेशा नहीं लगा, ये फंस सकते. लास्ट ईयर यूपीएससी ऑप्शन फॉर्मेट बदल दिया, बट 2 क्वेश्चन में बदला. और जो छाती पीटी है ना राजेंद्र नगर ने, सर बर्बाद हो गया. बाकी तेरे 120 आ रहे थे. क्लियर? नाउ लेट्स स्टार्ट. sources of law. In one simple, clear-cut line, law is nothing but a rule which applies indiscriminately to all actions. You're creating a sense of uniformity of conduct. And there is absolutely no universal definition of law. And every country, in every context, will have its own understanding of law. For instance, when we do fundamental rights, we'll come back to this point. Article 12 defines state. Article 13 says no law can violate a fundamental right. And even in 23, constitutional amendments are not law as per 13 clause 2. Constitutional amendments are not law only for the purposes of 13 clause 2. That is why there cannot be a universal definition. And just think about it logically. 13 clause 2 says no law can violate a fundamental right. If constitutional amendments were law, then no constitutional amendment could change anything in a fundamental right, even if you wanted to improve it. So if constitutional amendments were law, you would effectively fossilize the constitution. The constitution would be incapable of growth. This is why constitutional amendments are not law, even today. This is as per judicial interpretation. And it is also in the Constitution. Clear? This is why there cannot be a universal definition. Depending on who you are, where are you positioned, how do you look at things, you can try to define law in multiple ways. The first way to define any kind of law is the basis of that law. That basis could be, where does the law occur from? Is it something that it is too obvious to even worry about? That's called natural law. Morality or conscience is a natural idea. Do I need to write down on a piece of paper that you have the right to breathe? No. So, nature. Is it a reasonable, rational law? It is rational to say that don't steal something of somebody else's. It does not have to necessarily come from a structured idea. It fundamentally seems wrong. Third, religion. A lot of our society and the practices in our society is governed by different formats of religion. And if the religion says X is right, Y is wrong, and you're making a law in a society that follows that religion, you will take the religious idea and convert it into a law. Yes? A valid custom recognized for Hindu marriages is not your 7th circle of fire. It's not your ek do chutki sindoor. It is saptapadi. The first 7 steps around the circle of fire. Because that's a valid custom. Has been recognized in religion. And then ethics, of course. It has to be morally right. That's one way of going about it. Another way of trying to define law is, where did you find this idea? Because religion is very abstract. It can be different for different societies, for different communities. But where did you find the idea that X should be done or Y shouldn't be done? First is customs. A reasonable custom, a valid custom, a custom which has been going on for a very long time. There are so many customs in India that we have incorporated into law. Your entire 5th and 6th schedule is based on recognizing customary rights. Why do you give autonomy to tribal regions? So that they can follow their own custom. Precedent. What has been decided will be followed over a period of time. We'll do this in detail. And of course, you've made a law out of it. There is a law that says X is to be done, so X has to be done. The third is, what kind of an impact does that law have? Does it uplift society, restrict society, empower it, curtail it, depending on what it is? Fourthly, how is the law presented in front of you? Is it written in one document? There are multiple laws which talk about the same thing. Indian Penal Code is a consolidated criminal law. But before our labor codes were executed, we had 10 different employee-employer laws in the country. So multiple laws. Is it being written in a formal text? Is it a law? Is it a by rule? Is it a delegated legislation? Motor Vehicles Act, Motor Vehicle Rules. Mines and Mineral Act, Mines and Mineral Rules. RTE Act, RTE Rules. How is the law being presented? And lastly, what is it trying to achieve? The legislative intention and the objective behind the law. ये प्री में आएगा नहीं, बट ये कॉन्सेप्ट 5 मिनट का जरूरी था. ये रट के जाना है नहीं, आगे. So therefore, when we actually try and identify the sources of law, there are essentially 3 primary sources of law: custom, judicial precedent, and legislation. This custom also incorporates religion and everything else. And does it mean that any random custom could be converted into a law? The custom has to be reasonable, has to exist consistently over a period of time. It also has to be across ages. ये नहीं हो सकता कि 20 साल हुआ फिर 10 साल बंद हो गया फिर 20 साल हुआ. It has to be consistently present. Judicial precedent. What Sanskrit is to Hindi, Latin is to English. A boring language nobody speaks. मैं तेरे को बोलेगा तुम किम करोती, तेरे को बुरा लगेगा? नहीं, मेरे को लगेगा. What Sanskrit is to Hindi is what Latin is to English. And when these principles were being developed, the language of English wasn't developed. So as a result of this, you had a lot of Latin. The origin of judicial precedent comes from a Latin phrase called stare decisis. The principle of stare decisis. STAREDECIS. Will it be asked in the exam? No. कोई प्री में पूछेगा what is the meaning of stare decisis? No. But it is the origin of judicial precedent. Judicial precedent simply means the judgment of a higher court has to be followed by the lower courts. And this is a principle which is universally followed depending on the legal system. Now, does this mean that every line of every judgment given by the Supreme Court in India has to be followed across all courts? No. This is something which might be new information for all of you. So listen to this carefully. Every judgment has 2 parts of it. There are 2 parts to a judgment: a substantive part and a supportive part. The Latin words for this is ratio decidendi and obiter dicta. Do we need to remember these names for the exam? No. But do we need to know this? Yes. Because this clears a lot of your concepts. What happens is, when you go to the Supreme Court with a case, the court formulates certain core legal issues and gives judgments on those core issues. And while you are giving a judgment on these issues, the Supreme Court also makes random statements here or there. The privacy case was never just about privacy. It had the issue of the speaker, it had the issue of the validity of Aadhaar, and from there the court came to privacy. Yes or no? The Puttaswamy judgment was never about just privacy. Puttaswamy didn't go to the Supreme Court and said, excuse me sir, can you please tell me is privacy fundamental or not? वो तो गया था to challenge the validity of the Aadhaar Act. फिर कोर्ट बोला मैं वेट ही इसके लिए कर रहा था, कोई आए तो. How do I make the lives of UPSC aspirants miserable? By giving them a landmark judgment that generations will have to remember. So they identified some core issues. Is the Aadhaar Act constitutional? Can the court review the powers of the speaker to declare a bill as a money bill? And what is the status of privacy in India? This was the ratio of the Puttaswamy case. A part of it is still pending, by the way. अब उसमें खेलते खेलते सुप्रीम कोर्ट ने बोला privacy is essential and privacy includes bodily privacy and it also includes homosexuality, your choice. Your choice to be intimate with the gender of your choice is a part of your autonomy. So in the Puttaswamy judgment, the Supreme Court, as much as it could, said that homosexuality is an instrument of privacy and privacy is a fundamental right. But did the Puttaswamy judgment decriminalize homosexuality? No, because it was obiter. It was not the substantive part of the judgment. Then in the Navtej Singh Johar case, the lawyers took Puttaswamy to court. Supreme Court ने बोला, देख आपने बोला ना उधर, अभी लिख के दे, लिख 377 decriminalized. So Puttaswamy became a catalyst for Navtej Singh Johar's judgment. आया समझ में? So when we're talking about judicial precedent, this is law. In Vishakha's case, the Supreme Court effectively wrote down a law. In the ECI judgment, the Supreme Court has effectively written down a law. You have to follow it. This is judicial precedent. It constitutes law. Is it right or wrong? I will see you in the mains crash course for that. But ye idhar. ठीक है? Are we clear with judicial precedent? It is nothing but the authority of a judgment to be binding on lower courts. And all judgments are not binding on all lower courts. And all parts of all judgments are not. Next. The simplest source of law, law. Technically, legislation also is a Latin term, comes from legis and lactum, but the theoretical meaning of legislation is not just the law, but the intention behind lawmaking. But in India, the courts do not get into the intention behind law. You cannot question the legislative intention. वो नहीं कर सकते. So three primary sources. Are we clear with the three? Custom, precedent and legislation. इसके ऊपर कुछ नहीं कर. बिल्कुल relevant नहीं. Now we come closer to the Exactly. Of course, arbitrariness, fairness, rationality can. Yeah, yeah, yeah. Of course. Now, types of laws. दुनिया में दो तरह के कानून होते हैं, इंटरनेशनल लॉ एंड नेशनल लॉ. एंड नेशनल लॉ को म्यूनिसिपल लॉ भी कहते हैं, बट दिस इज नॉट द सेम एज म्यूनिसिपैलिटी लॉ. म्यूनिसिपल लॉ और नेशनल लॉ और डोमेस्टिक लॉ इज द सेम थिंग. ठीक है? We use national or domestic law interchangeably, and there are two kinds of international law. There are two kinds of international laws, depending on who is the law governing, who is the law for. If the law is governing countries, it's called public international law. Kyoto Protocol is a public international law. Paris Climate Action Deal is a public international law. WTO rules are public international law. A law which governs the conduct of countries is public international law. And the fact of the matter is, though you will hear of treaties and conventions and covenants and declarations, in the eyes of the law, they're the same. There is no legal difference per se between a treaty, a convention, a covenant, nothing. Protocol, it is the same. Otherwise, you can have some varied differences, but legally they're the same. तो कभी ये confusion नहीं रखना है, sir, what is the difference between protocol of Kyoto Protocol and the Paris Climate Action Pact? Legally, they're the same. They will always be the same. And that law, which is governing the conduct of two individuals, which has an international implication, is private international. It is the most abstract of them all. For example, if an Indian citizen and a Pakistani citizen enter into a business contract which has to be executed in Sri Lanka, that is private international. ठीक है? ये सिलेबस में नहीं, ना प्री में ना मेंस में इसके लिए वकालत करना पड़ता है, कोई फायदा है नहीं. ठीक है? क्लियर? हमको मतलब है इस. The first question is, who is the national law for? If the national law is governing the government or governing the relationship between the government and the citizens, it's called public law. This can be asked in the prelims. Public law is any law which governs the government or the relationship between the government and the citizens. Anything which validates conduct, that is public law. A law which governs the government is administrative law. It's an example of public law. A law which is governing the conduct of the government and the citizens, or the relationship between the government and the citizens. For example, criminal law. Indian Penal Code is public law. If X has killed Y, it is the duty of the government to stop X from doing so and to punish X for killing Y, which is why criminal law is public law. Indian Contract Act is public law. If X has sold goods to Y, Y has not paid X, then you have breached contract, a valid contract between two people. It's a public law. Constitution is also public law. It is governing the government, and through fundamental rights, it's governing the conduct of the government and citizens. So can I say Constitution is public law? Yes or no? Yes. Private law is about the private matters of people. What are the private matters of people? Marriage, divorce, children, inheritance, property. So personal law is private law. Hindu Marriage Act, Muslim Marriage Act, Special Marriage Act, Hindu Succession Act, these are all private laws. And therefore it is in the news, it has been perpetually in the news to have a uniform private law. Uniform Civil Code. That's the first layer of classification. Then you can classify domestic laws in multiple ways. One, what happens if you break the law? If you're going to jail and you have to pay a fine, or you only have to pay a fine, it's criminal law. If you have to compensate, if you have to return what you had taken, if you have to come back to original status quo, that is civil law. Consumer law is civil law. Consumer protection law is civil. You compensate. You return the product. You recall for a defective product. You don't send anyone to jail for Consumer Protection Act. It is a civil law. There are arguments that you should have criminal provisions also, but it is a civil law. But Juvenile Justice Act is a criminal law. Prevention of against sexual offences against children is a criminal law. POXCO. You violate it, you go to jail. Representation of People's Act. It's in the news. Criminal. You can be sent to jail. Therefore, it has a criminal interpretation. And the same issue can have civil and criminal consequences both. Defamation, you can go to a court and seek compensation. You can go to a thana and file a complaint. So defamation is civil and criminal. Section 499, I think, of the Indian Penal Code refers to criminal defamation. Right? The other way is how detailed is the law. For example, Indian Penal Code is a generalist law. It lists down the maximum number of crimes and the punishments for those crimes. But the Juvenile Justice Act is a specialized law for crimes committed by children. The Prevention of Money Laundering Act is a specialized economic offences law. So, आपने सुना होगा ना कि मल्टीपल धाराएं लगी हैं, कि आईपीसी की भी लग रही है, पीएमएलए की भी लग रही है, इसलिए लगती Clear? Economic Offenders Law, you have a Fugitives Act now, a specialized economic criminal law. And the general rule is special law over general law. If the Economic Offenders Law prescribes X as a punishment and IPC prescribes Y as a punishment, X over Y, because it is special. Add नहीं करेंगे कि उनका 10 इनका 10 चलो 20 साल. Special law over general law. Are we clear on this at the back, everyone? See, the third way is, what does the law do? कर क्या रहा है? IPC is a substantive law. X is a crime, Y is a punishment for it. ठीक है? But इसको execute कैसे करें? The execution part of it is in procedural law, CRPC. इस थाने में FIR होगी, एविडेंस ऐसे आएगा, ऐसे एग्जामिन होगा, ऐसे रिकॉर्ड होगा, ये नोटिस जाएगा, ये विटनेस को जाएगा. CRPC is as much a law as IPC, right? So what does the law do? Does it tell you what is right and what is wrong? And does it tell you how to go about something if a wrong has been committed? The how to go about it is procedure. What is right and what is wrong is substantive. A basic difference between the two. Clear? Good to go? Great. That's it. Type of laws में इसके ऊपर कुछ नहीं. Now, this is the part that most of you might not be very familiar with. बहुत ध्यान से देखना, बहुत ध्यान से समझना. Everybody okay? In your UPSC preparation, you would have come across a syllabus topic which says comparing constitutions of the world, right? Why do we have to compare the Supreme Court of UK and India? Why do I have to compare equality provisions of America and India? Those have been previous year mains questions. They come from similar systems. They come from similar systems. What is a legal system? A legal system, very simply, is a general ecosystem of laws and institutions. कि इस देश में जुडिशरी चलती कैसे है, इस देश में लॉ की औकात क्या है, इस देश में लेजिस्लेचर और जुडिशरी आपस में डील कैसे करते. You will see common systems applicable across countries in the world. The two oldest ones, that's where it all begins, is common law and continental. India has a very strong influence of the common law system. बहुत ध्यान से देखना ये क्या होता है. पहली बात तो common law does not mean commonly applicable. The origin of the common law system goes back to England, where in cases where you had an issue with the crown, you had an issue with the leadership of monarchy, conflicts with the monarchy, so a legal system was developed around it. That is the origin of the common law system. In the prelims, would you be asked about this in detail? No. But a common law system is generally believed to have originated in England. And wherever the colonial expansions of England happened, the common law system expanded. India, England, US, Canada, New Zealand, Australia, all of them are common law systems. Which is why these are the countries which you are asked most often to compare India with. Because we come from the same classification. This is like class mammalia. Environment में पढ़ा है ना? We are class mammalia. So class puglilia. This, ठीक है? This doesn't mean that India is 100% common law. We are 70% common law, little continental, 20%, 10% little social, but majoritively common law. Common law की features क्या है? And how are these features actually implemented in India? The first is, in common law countries, judicial precedent is of a very high value. Very, very high value. Court ने बोल दिया तो बोल. Judgments of higher courts will always be given an authority and will be applicable to all respective lower courts. When we say that a judgment delivered by the Bombay High Court is applicable throughout the territory where Bombay High Court has jurisdiction, it's because of this common law principle. It's not the case in France, by the way. When we say that the Supreme Court of India's judgment is applicable to the entire territory of India, it's because India is a common law. This is not true in France. France is continental. A French Supreme Court judgment is not applicable to the entire territory of France. ये fact है, check कर लेना. It's called courts de session. इसे bonjour, session, croissant. ठीक है? Clear? 2. In common law countries, the judiciary is a technical service. It's a technical organ. You have to be a lawyer or you have to have a background in law to become a judge. ऐसा Western Europe में नहीं है. कोई भी जज बन सकता है. In India, you have to be either trained in law or have a background in legal academia to become a judge. In fact, your criteria to becoming a Supreme Court and a High Court judge is that you should have been a lawyer for 10 years. Isn't that the case? You have an entire system of local or regional judiciary or state judicial services where you necessarily need to have a law degree. If you don't have a law degree, you cannot write the state judicial services exam. ऐसा यूरोप में नहीं है. हमारे यहाँ, at least Western Europe. Third, this is very interesting. You would have seen, na, see, कानून अंधा देखा है? वो ऐसा, which you would have thought for other reasons, but no. ऐसा वो blindfold करते हैं ना उसको, किस लिए करते? Hey, it's not what you think they do it for. It's not to spice up judiciary, Baba. Because we have an adversarial system. The judge is a spectator. Our Honorable Chief Justice, Justice Chandrachud, was recently attending the India Today conclave. And this is the first time in Indian history a sitting Supreme Court judge has delivered a live interview. It was phenomenal. And he spoke about this, that as judges, they have to be immune from whatever is being spoken about. They can only decide a case on the merits of the case, on what is being placed before them on record. They may know who's the real culprit, they may know what is the reality, but unless you have enough evidence to support the truth doesn't matter. The truth is only what can be proven in a court of law. This is called an adversarial system. The lawyers are fighting with each other. It is not about finding the truth. It's about representing the best interest of your client. It may not necessarily be the truth. It may not be the truth. ये हमारा country है. US भी ऐसा है, England भी ऐसा है, Australia भी ऐसा है. It's always A versus B. The lawyer of a murder accused and a government prosecutor do not sit in a high court canteen or a criminal court canteen. आओ चलो सच पता करें. And lastly, the judiciary will interpret the law. The same crime of murder can translate into 7 years of jail, can translate into life imprisonment, and can translate into death penalty. Who decides? Judge decides. Yes? There are so many constitutional interpretations given by the court. Kesananda, Minerva Mills, Quixote Zolohan. क्यूटो जोलोहान सुप्रीम कोर्ट लिख के दिया ना, after the speaker has decided you can challenge the defection in the court. लिख के दिया ना बस. या फ्रांस में करके दिखा. आप ये इटली, फ्रांस, वेस्टर्न मेनलैंड यूरोप में करके दिखा. नहीं होता. Judiciary in a common law system has the powers to not only interpret the law but fill gaps in the law. Compare it to continental. Continental is a bourgeois legal system, intellectual legal system. It is also called the Romano-Germanic legal system. और ये कॉन्टिनेंटल की ना बहुत अलग अलग वैरायटी है, कोविड वेरिएंट के जैसे. I know, dark joke, but still. They have a Portuguese, they have a, they have a Roman, they have a German, they have a Spanish continental legal system, very varied. The birthplace of common law is monarchy, England. The birthplace of continental is the universities in Europe. The scholars तो आप जानते ही, खुले दिल के होता है ना? Academicians will always work in an idealistic world. So the legal system is like that. First, legislative supremacy. The law is the law. There's nothing more than parliamentary law or whatever law has been made in that country. And interpretations to the law is not given by the judiciary, by the scholars, by academicians. बहुत ही informal system है. वहां लक्ष्मीकांत की बहुत औकात है. Clear? Here, D.D. Basu may have interpreted a provision as X. You can quote his interpretation in a court. कोर्ट को अच्छा लगेगा तो सुनेगा. D.D. Basu is not binding in India, but D.D. Basu would have been binding in France. वो सुबह उठ के लिख दे, Article 21 includes privacy, तो privacy है. I'm oversimplifying it, but है. यहां करके दिखा तू. Two, there the judiciary is very generalist, because the judiciary doesn't interpret, because the judiciary simply applies the law. If you have to apply the law, then why do you have to be a lawyer? कानून में तो लिखा है ना ABCD, बस खत्म, अप्लाई कर, आगे बढ़. You don't need to be a legal background person to be a judge in Western mainland Europe. You don't. A doctor, a scientist, a lawyer, engineer, anything else. That doesn't mean that they don't teach law there. They do teach law there. But a background in law is not compulsory to be a judge in continental legal countries. You can have non-judicial members as judges in continental legal countries. Yes? Third, inquisitorial. South Korea is an example. So, for example, if in India there is a case before a court which says that due to a construction activity, the environmental balance of a village is threatened, the judge will sit in the courtroom and will only decide on the basis of the facts before the judge. That's it, nothing else. South Korea, which is a continental legal system, the judge, the lawyers, the parties will go on a fact-finding mission to that village, will investigate themselves. Liberal log hai na? There are no lines. Pursuit of truth. Yahan nahi hota. Fourth, Because you're not technical, you're not competent, you cannot review legislation. Inspired from common law and continental is a socialist legal system. Socialist legal system is a legal system which is heavily emphasizing public law. कि private property होनी ही नहीं चाहिए. The state is the strongest element of welfare. ठीक है? Now you will notice India has a little bit of all of the three. Majorly common law. Do we not have tribunals in India? Do you have non-judicial members in tribunals? Yes. Directive principles is nothing but a socialist legal system. Yes. Every time the government has gone on a nationalization mandate in this country, from banks to insurance to general insurance to coal, it's nothing but a socialist legal system. Yes. We are majorly common law, but we have a little bit from here and we have a little bit from here. And fourthly, you have the international legal system, depending from, say, organization to organization. The UN will have its own legal system. The EU will have its own legal system. Bilaterals like SAARC will have their own legal systems, right? And bilateral countries will have their own legal system. ये syllabus में आपके नहीं, ना pre में है ना technically mains. But remarkably, the European Union has one of the most advanced international legal systems. Now from here, we move to rule of law. Important है, एग्जाम में सीधा सीधा आता है, थोड़ा सा डिटेल में करें. Originally a concept of A.V. Dicey, right? The basic principle of rule of law actually comes from France, Le Principe da Legati, but it was formalized in a structured work as a formal legal concept by this professor in England called A.V. Dicey. And in fact, in India also, our Upanishads, to a very large degree, do give some contextual reference to rule of law. Will we be asked the historical origin of rule of law in the prelims? No. But A.V. Dicey's rule of law has three simple principles. And these three principles are non-negotiable. Rule of law necessarily means these three things. One, absence of arbitrary power. Absence of arbitrary power. अगर arbitrary power है, तो वो direct rule of law का violation. Now, what does this mean? It means, number one, no person could be punished or could be made to suffer in any form unless there is a legal violation. There has to be a law which specifically prescribes X is wrong and Y is right. If that is not the case, it's a violation of rule of law. Two, the government can only punish, and only the government can punish. It has to be done by an appropriate authority, and only on the basis of the violation of that rule of law. Third, under no circumstances, any wide discretionary power. Fundamentally, the idealistic concept is the enemy of rule of law is discretion. We will soon come to realize that discretion is a necessary evil. You cannot live without it. You cannot live with it. And that is why, for discretion, which is in administration, you have principles of natural justice. But principally, fundamentally, discretion kills rule of law. Fourthly, if the authorities are deciding something in a certain manner, it has to be done in strict accordance with the law. बस ये चार चीजें याद है और कुछ. And you will see all of this will be in some form or another, in some way or another, reflected in the Indian legal system. एक एग्जाम्पल देता हूं. फॉर एग्जाम्पल, if there is a transport department and that transport department has an RTO inspector, that RTO inspector is randomly stopping vehicles on the road, confiscating them without specific reasons for doing so, that is a clear violation of rule of law. If the government orders a shutdown of a road, it has to close that road, build something up, without giving adequate time, notice, reasons, that is a violation of rule of law. Clear cut. But if the government says all primary schools in a state will be shut down after 6 months if you don't follow safety guidelines, you were given 6 months, you didn't follow your safety guidelines, the government shut down that primary school, that's okay. That's perfect. If a minister has the authority to award certain contracts and that has been done arbitrarily or on a preference or on a favoritism basis, that's a violation of rule of law. Each of these principles of rule of law in some form or another are mentioned in the Indian legal system. Article 14 is the beginning of rule of law. We'll come to equality, but this is how it is. When I tell you that no person shall be prosecuted unless for the authority of law, it's nothing but the application of Article 14. Is it not? The second principle of rule of law is equality before law. Second principle. 4 things. 1, unless there is a violation, the government can't punish. 2, no matter who you are, what your caste, religion, status, power matrix is, you're equal before the law. 3rd, and this is very important, for rule of law to exist, for rule of law to be upheld, the courts must be independent of the executive. This is a prelims question for you right here. Which of the following is necessary for rule of law? And one of the options is independent judiciary. That is correct. If you do not have an independent judiciary, how will you judge whether this was a violation in an unbiased manner or not? Independent judiciary is a precondition to rule of law. 4th, you cannot have specialized courts separate for the government and for ordinary citizens. Government disputes in the Supreme Court, our disputes with the government in the Supreme Court, our disputes with the government or governmental disputes or disputes between one another, all of us have the same legal system to go to. You can create special courts on branches of law, but you cannot exclude anyone from going to court just because you are not in the government. Second principle. 3rd, pre-question right here. Rule of law and supremacy of law. For the law to be unbiased and for the law to be equally applicable to everyone, there cannot be anything greater than the law. For the law to be uniformly applicable to anyone, for the law to not distinguish against anyone, the law has to be above everything. If a law does not have the remedies for its violation, It cannot be supremacy of law. Understood? If we say supremacy of law should mean the following, then there must be recognized rights with remedies. I cannot call the Constitution supreme if it didn't have Article 32. It is pointless. What do I do with those rights if I cannot enforce those rights? And those rights have to be enforceable in a court which is independent. Yes? So every time, for example, do you remember a Supreme Court judge who was an ex-Supreme Court judge who was allegedly accused of sexual harassment? And the Supreme Court set up an internal committee to figure out whether he did it or not, of which he was a member. Rule of law cried that night itself to sleep. रोया है वो. A law without a remedy is not a supreme law. A law without a remedy enforceable in a separate court is not a supreme law. It's that simple. Then, if the courts don't have judicial review, then you do not have rule of law. Because then the parliament can make the law to whatever it is. So, agar pre mein पूछे, rule of law is judicial review is an essential component of rule of law. That is correct. Otherwise, how will I check the validity of a good law? If the law is being biased, IT Act, Section 66A of the IT Act, the Supreme Court had the power to declare Section 66A of the IT Act as unconstitutional, which is why you could still maintain supremacy of the law. Law will only be supreme if it is worthy of being supreme. And the only way it can be worthy of being supreme is if the court has the power to challenge and question it. If the law has the powers to itself to be challenged, if we have the powers to challenge the law in a court. Yes? Rule of law, independent judiciary. Rule of law, unbiased decision-making factor. Rule of law, judicial review. Rule of law, remedies. ये सब linked है. यही प्री में उठ के ऑप्शन में आता है. आता है ना? ये कभी नहीं पूछेंगे कि रूल ऑफ लॉ इज रिफ्लेक्टेड अंडर व्हाट आर्टिकल. वो मेंस के लिए है. प्री में तो कॉन्सेप्ट पूछते हैं. मेंस में तो 13 आर्टिकल 13 क्लॉज 2, 141 सुप्रीम कोर्ट, 141 कॉन्स्टिट्यूशन, 435 सीआरपीसी. इन द इंटरेस्ट ऑफ लॉ एंड जस्टिस जो करना है करो. Suo moto powers of the Supreme Court is nothing but upholding rule of law. If the Supreme Court has constitutional powers to do whatever it deems fit in the interest of law and justice, that is nothing but rule of law. ये प्री में पूछेंगे. कहां लिखेंगे? मेंस. जब हम मेंस में सुप्रीम कोर्ट का पावर्स एनालाइज करते हैं तो हम ये लाइन लिखते हैं that the inherent powers of the Supreme Court to do to take appropriate action in the interest of justice is nothing but its measure to uphold rule of. But is rule of law written in the Constitution black and white? No. बस. तो हमको इससे क्या याद करना है? एग्जाम में क्या लिख के आएंगे? What do we need to know for the pre? Number one, is it mentioned in the Constitution? Yes or no? What are the three pillars of rule of law? Pillar number one, absence of arbitrary power. 2, equality before law. 3, supremacy of law. These are your three pillars. What are your essential ingredients for rule of law? Independent judiciary, yes or no? Judicial review, yes or no? Law with remedy, yes or no? बस. इसके बाहर तो नहीं आएगा. कर लेंगे. सही करके आओगे? पक्का? नाउ डू यू अंडरस्टैंड द पर्पस ऑफ मैग्ना कार्टा? ये ज्ञान नहीं, क्या चाहिए हमको? बाकी हम चाय पे ज्ञान दें। चलो, तो 2 बार हो गया। चलो, नाउ दिस इज रूल ऑफ लॉ, says anything which is arbitrary, is discretionary, is an insult to rule of law. But in a welfare country like India, can you survive without discretion? No. Can you survive managing and uplifting a country the size of India without discretion? चांस ही नहीं है बॉस, चांस ही नहीं है। You are aspiring to become a civil servant, you're able to function well because of the enormous discretion that you get. And to regulate that discretion, you have principles of natural justice. सबसे पहली बात, rule of law applicable to law. Principles of natural justice applicable to administrative actions. You will challenge an administrative action in a court on the basis of principles of natural justice. You can challenge the fairness of a law in a court on the basis of rule of law. फर्क समझ में आया? You will challenge Section 66A in the Supreme Court, fundamentally because it's a rule of law violation. It's unfair. It's arbitrary. It's not treating people equally. But when the local administration sends an arrest warrant to you, that's an administrative hiccup, violating principles of natural justice. That is how both of them come together. मेनका गांधी का केस यही तो था। The passport officer, the regional passport officer under the Ministry of External Affairs sent a notice to Menka Gandhi saying passport दीदी नहीं जाना बाहर, चिची नो नो। मेनका गांधी बोला क्यों? पब्लिक इंटरेस्ट। मेनका गांधी बोला अच्छा abhi court chal, and courts are also sitting for a long time. The last time the courts had a gala time was Minerva Mills. वो भी बोले कि हाँ आओ आओ। But the problem, what was the problem? The regional passport officer did not give an opportunity to Menka Gandhi to explain why her passport should not be surrendered, and did not give a reason to Menka Gandhi why they are taking it. That's an administrative problem. That's not a legal problem. उसकी आड़ में वो कोर्ट गई, बोला मेरा फंडामेंटल राइट वायलेट है, राइट टू ट्रैवल. And that's where due process of law and procedure established by law all came to being. सरकारी वकील बोला कोर्ट में तो उसमें कानून में तो ड्यू प्रोसेस ऑफ लॉ लिखा है, सॉरी प्रोसीजर एस्टैब्लिश बाय लॉ लिखा है. किया ना हमने प्रोसीजर, नोटिस लिख के भेजा ना. You may like someone, but the question is, why do you like someone? Why do you like someone is due process of law. You liking someone and doing all the maths right, ki morning, good night, eat lunch, baba babu, is procedure established by law. None of it's going to work, by the way. But clear? Understood? ये फर्क. Now there are two traditional principles of natural justice. लैटिन याद करने की जरूरत नहीं है, एग्जाम में कोई नहीं पूछता है. There is one new modern principle as well. The two traditional principles are nemo judex in causa sua. याद रहेगा? नहीं. रूल अगेंस्ट बायस। रूल अगेंस्ट बायस मतलब कोई भी इम्पार्शियलिटी नहीं होनी चाहिए, ना जज में, ना प्रोसेस में, कहीं पे। इसके ऊपर एग्जाम में आएगा नहीं, हमें पढ़ना नहीं। मेंस में इसमें 1 घंटा हम बकर करें। यानी simple impartiality. So what is causing partiality? What are the reasons why there could be a bias? There could be a personal bias. Yes, कि जज का गाड़ी खराब हुआ था टाटा का, तो अब वो टाटा के खिलाफ ही जजमेंट दे रहा है। पर्सनल बायस। Pecuniary, financial. This is a real Supreme Court case, by the way. The Supreme Court actually settled this matter. Your new NCERT textbooks have been announced. Oh, so sorry for you guys. दोबारा पढ़ना पड़ेगा न्यू बुक। अब 5 साल तक ही चलेगा न्यू एनसीईआरटी, ओल्ड एनसीईआरटी और ओल्डर एनसीईआरटी। गलत प्रोफेशन चूज कर लिया। ठीक है, क्या होगा फिर? This NCERT, this is a real case by the way. There is a textbook selection committee which decides which author's book will be made an NCERT. So the textbook selection committee decided on a list of authors, and one of the authors was on the committee. हमको हमी से चुरा लिया। I gave you your mains paper to correct to you. सबका रैंक 1 आएगा ना? So they challenged it in the Supreme Court. Supreme Court बोला इधर लिखा है मेरे, this is a violation of principles of natural justice because there is a bias. ये real case है. Similarly, departmental bias. कोई नहीं, लेट लंच करेंगे तो लेट आधा घंटा ब्रेक दे देंगे, तुमको क्या लाइफ है तुम्हारी? Departmental bias. What is a departmental bias? Give you an example. So a departmental committee had to recommend the names of a few officers for promotion, and one officer in that department had to prepare that list. He recommended 10 names. 10th name was his name. मैं भी बनेगा सेक्रेटरी। तो बाकी जिनका नाम नहीं था बोला इधर आ, सेम बैच, हाउ यू सेक्रेटरी मी नो? सुप्रीम कोर्ट स्टक इट। समझ में आया? डिपार्टमेंटल बायस। द टफेस्ट बायस टू प्रूव is preconceived bias. If someone fundamentally has a problem with people who belong to the transgender community or people who are like people of the same gender, अब उनके actions में reflect कर रहा है, क्या कर लोगे? But they followed everything right. But it's very tough to prove, but a principle nonetheless. The second principle is the rule of fair hearing, which was Maneka Gandhi's major issue. You have to hear both the parties. Time से notice दो, evidence दिखाओ, एक दूसरे से पूछो तुमने ये बोला बोला, नहीं बोला बोला, cross examine होगा, थोड़ा तमीज से होगा. And these are all departmental hearings by the way. ये कोर्ट नहीं है, ये इंक्वायरी है एडमिनिस्ट्रेशन की. Even an administrative inquiry, a government inquiry has to follow principles of natural justice, because principles of natural justice are only applicable to administrative action. You can't question Keshananda Bharti, it violated principles of natural justice. कि केशवानंदा को नहीं पूछा कि जमीन दे कि नहीं दे. ठीक है? Remember this, I'm reiterating it. Principles of natural justice only and only applies to administrative hearings. ठीक है? Then a new principle has come up in modern jurisprudence, which is called reasoned decisions. So if there is a government inquiry, there's a government report, there's a government department, and they've decided this. आपने कोविड के लॉकडाउन ऑर्डर्स देखे हैं? उसमें लिखा होता था कि हम क्यों कर. Compare a COVID lockdown order to a curfew order of the 60s. The 60s curfew orders used to be 2 paragraphs. Shutting, okay, bye, see you. But do you see the COVID lockdown orders? In view of the emerging rise in COVID cases, in compliance with WHO directives, under powers of DM Act, Disaster Management Act, Epidemic Diseases Act, we are therefore doing this. You have to give reasons for your decision. अगर कोर्ट कर रही है तो आप क्यों नहीं कर रहे? These are your 3 principles of natural justice, but they will have some exceptions. Simple एक लाइन के exception है, इसमें concept बस concept लेके जाना. Exception number 1, urgency. If I had to demolish a building tomorrow, otherwise in 2 days the building will collapse and the people will die, I cannot wait for notice to be sent, because by the time they reply to the notice, they will be dead in the building. Yes? Urgency. Urgency is an exception to principles of natural justice. 2, confidentiality. मेरे को क्यों नहीं बताया कि मेरे फोन में Pegasus डाला? Nothing called Pegasus, huh? 3, routine matters. If a university has suspended a student, administrative action hai. If a university has suspended a student because the student has not completed attendance or academic performance has been poor, you can't take the university court to university to court कि कैसे ली गई मेरे को, कैसे suspend करा? अरे करा तो करा. It is the routine power of the university. The university has the powers to suspend a student on low attendance. मेरे को नोटिस क्यों नहीं दिया कि सस्पेंड करने वाले थे? चचा है तुम्हारे. नेक्स्ट, इम्प्रैक्टिकलिटी. कि एक सेंटर में चीटिंग हुई तो सिर्फ एक सेंटर के ही पेपर्स कैंसिल करेंगे, पूरा एग्जाम करेंगे ना कैंसिल, कि बस यही 1500 रोल नंबर करना. इट्स इम्प्रैक्टिकल ना to send notices to each of those 1500 students who have cheated in a public exam. You cancel the entire exam. That is why when some of your government exams get cancelled because of cheating or because of leaking of papers, the court never entertains ki the leaking kya bolte hain, leaking the cancellation of order has to be revoked. No. कि हमको क्यों नहीं बताया, आप कैंसिल करने जा रहे थे, मैं छुट्टी पे नहीं जाता. It's impractical. Then legislative action. Constitution में prevention of preventive detention लिखा है. Preventive detention is the opposite of principles of natural justice. I will tell you that tomorrow I am going to detain you because you're a threat to society. You will run away. The law gives me the power to do this. So you cannot challenge an order issued by the SP of the district on principles of natural justice. Are you understanding the concept? Next, no rights violation. कुछ हुआ ही नहीं तो किस लिए? There has to be a right violated just because you have a problem with the government order. UPSC regard now all applications will only be filled online. तो नहीं ऐसे नहीं. ऐसे क्यों ऑनलाइन? कुछ गया आपका? Are they preventing you from writing the exam? No, you cannot challenge. Then statutory exception, the necessity है. लॉकडाउन था तो था, करना पड़ा. If it had to be done overnight, it had to be done. That is why you will notice the court never agreed to hear any of the lockdown petitions. The Supreme Court set up the only suo motu case Supreme Court has heard in the last 3 years is the management of oxygen in COVID. So many times lockdown orders were contested in the court. Court never paid attention. ये तो necessity था. Lastly, contractual agreements. If two people have decided to execute it in a certain way, they have. बात खत्म. And different laws will provide for different mechanisms. जैसे income tax act है. You go to an income tax tribunal. Complicated act है. You are entitled to legal representation. If you don't get legal representation, you can question the process. But in consumer, you can't. It's a simple law. It's a self-explanatory law. Okay. Will you be asked this in the exam? No. Exam में कितना आना चाहिए? इतना. Principles of natural justice and exceptions. Clear cut. Is any of this mentioned in the Constitution? Different laws, different statutes, different provisions. Is any of this explicitly as it is mentioned in the Constitution? No. And the Supreme Court, therefore, in the Menka Gandhi case in 1978 and the Tulsi Ram Patel case in 1985, clearly gave a judgment. If you are not following principles of natural justice, you are violating rule of law. Every country will have different sort of adaptations, like how there is no country in the world which is a purely capitalist, socialist or a communist country. Similarly, no country in the world is a purely common law, continental law or a socialist legal country, right? That is, for example, we also have judicial commissions, right? And those judicial commissions are fact-finding commissions, like the Nanavati Commission. That is a continental law concept. So we've also adopted it. So as nations evolve, they also evolve best practices from different legal systems in the world. But the origin is this. It would be appropriate to say that India is majoritively a common law system with some resemblance to continental law and a very limited sort of an interface with socialist. And India, of course, subscribes to the international legal system. Now, we discussed rule of law, we discussed principles of natural justice, and we understood that there was a common theme between these two concepts. The spinal cord behind these two concepts was in fact, in a way, controlling the government, keeping a tight leash on the government. And that gives birth to an idea called constitutionalism. Constitutionalism, constitutional law, and constitution. Three very important terms. The UPSC has asked several questions on constitutional government, the meaning of it, the principle of limitation. So we must cover everything in and around it with a bare limited amount of detail. Now, we start with constitutionalism. For students of political science, this could be an hour-long discussion for you. But for us, who's writing the prelims exam, in one line, constitutionalism is a theory, a belief, an idea, or an ideology, which simply means limiting the powers of the government. The government cannot be given uncontrollable powers, which means if there is rule of law, there must be some form of constitutionalism. Yes? So if there is a prelims question that says that constitutionalism reflects rule of law, that would be a correct option. Because rule of law creates that kind of an order in chaos, and constitutionalism also believes in limiting the powers of the state. Now, in your prelims, any option of any kind which has something to do with limiting the powers is the correct option. And I can add constitutional to anything. So a constitutional government is a government whose powers are limited. Understood? A constitutional state is a state whose powers are limited. Constitutionalism in its original form is nothing but limiting the powers of the government. This is the only one line that you need to know. Now, there are two forms of constitutionalism. This is something that I've added this year. The traditional original form is called negative constitutionalism. That all that the state can do, should do, would be in a controlled form. Just limiting the powers of the state. We're assuming that the state is just looking for an opportunity to transgress or to bypass that level of decency. So we're controlling. But that is not all that good governance is about. Effective statesmanship or effective societies are never just run on restraint, which is why a modern idea of constitutionalism is positive constitutionalism. All we need to know as far as prelims and positive constitutionalism is that if you're promoting welfare and you're insisting the state to also try and provide for welfare, then you're also positively constitutionalist. So is India negative and positive both? The answer is a resounding yes. How are we negatively constitutionalist? Article 13, Clause 2. No law can violate the Constitution. Simple. The best example I can give. How are we positively constitutionalist? Directive principles of state policy. Nudging the government to enact laws, policies, schemes that make the general standards of life better in the country. That's it. Anything beyond this is not important for the exam. We don't need to know thinkers, we don't need to know names, we don't need to know theories. We just need to know one-line meanings. Clear? Good. So if constitutionalism is an idea, we have to implement that idea. We are talking about limiting the government. How will you limit the government? You cannot limit the government by creating another institution. That would be counterproductive. That would mean it's a parallel government. You cannot limit the government by giving extraordinary powers to the judiciary. It will undermine the government. And that is why we bring rule of law to our rescue. We say that the one thing that is uniformly applicable to anyone and everyone is the law. So let us use law and put everything in a limited space. And that is constitutional law. Constitutional law is any law, any regulation, any provision, anything which is executing constitutionalism, which is limiting the powers of the government. And constitutional law is not just about the constitution. It could literally be anything. It comprises of the constitution, it could comprise of relevant statutory law, it could comprise of judicial decisions, it could comprise of conventions. If you think about it, when we have a customary convention of a sort, that when the president is appointing the governor, as a matter of convention, you speak to the chief minister of the state. So in a way, you're creating some form of limitation. Is it done through law? No. Is it done through a judicial decision? No. The doctrine of basic structure, which has been evolved through Keswananda Bharti, is an instrument of constitutional law. You're effectively saying that you can amend anything in the constitution except principles of natural justice, which the Supreme Court from time to time will keep on listing down. Doctrine of basic structure is your implementation of constitutionalism. It is an instrument of constitutional law. So don't be stuck up or don't be narrow-minded with our understanding of law. Law is never just an act. Law is anything which is enforceable. Remember our first meaning of law. Anything which is uniformly applicable without prejudice is law. Remember, customs were a source of law. Precedent was a source of law. Legislation was a source of law. This proves it. And this therefore consists of legal and non-legal norms. Non-legal norms are your conventions, customs, practices. So if you think about it, the Government of India Act of 1935 is constitutional law in its own right. It is in fact called a mini constitution. It gives you a federal court, which is now the Supreme Court. It talks about the sharing of powers between the center and the states. It talks about residuary powers left with the Governor General. It talks about emergency like situations. It talks about how the central legislature can execute or legislate in matters with respect to provincial legislatures. How is that any different from what we do? So can we call Government of India Act of 1935, which is a British law, constitutional law? Yes. So constitutional law is any law which gives a limitation on the state, that the state cannot do this, gives a structure to the state, lays down powers and functions and framework to the state. And constitution is just a type of constitutional law. You had the Government of India Acts of 1909, 1919, 1935. And then we sat down from 1946 onwards and we drafted a single law called the Constitution of India. The full form is the Constitution of India Act of 1950. It is a law, but it is a single law. What the labor code is for all employee laws is what the Constitution is for all constitutional laws. You've just put it all together in a single document, a single comprehensive document. So that establishes the structure of the state, the functions of the organs, the relationship that the organs have with each other, and the relationship that the government would have with the states. A constitution is nothing but a singular version of constitutional law. All constitutions are constitutional law, but all constitutional laws are not constitution. If it's written in one document, then it's a constitution. If it's written in 5-6 different laws, then it's constitutional law. And this is your hint. The difference between constitutional law and constitution is the difference between a written and an unwritten constitution. An unwritten constitution is basically constitutional law. You have 10 different laws dealing with 10 different things. Unwritten constitution does not mean that it's not written anywhere. If it's not written anywhere, it's not law. It's just written in 10 different laws. A written constitution means it's written in one document. It's codified in a single piece of legislation. Which therefore brings me, after understanding this, to classifications of the Constitution. Broadly, there are just two types. Very quickly, most of you know this anyway, and this is too basic. You classify constitutions in two ways. One, on the levels of government that a country has, and two, on whether it is written in a single document or multiple documents. That's it. When we talk about levels of government, now most countries in the world have either one level of government or two. If you have a twin level of government, you're called a federal country. A federal country does not mean state. It means a country where the center and the state governments exist. Federalism is the existence of two layers of government. It is not just about state governments. That's a classic mistake most of us make. So when we say Federal Bank of India, it's actually a national bank. When we talk about the United States, we hear of Federal Bureau of Investigation. Federal actually means national. Federal is national in a country which has two layers of government. So Federal Bureau of Investigation is a national intelligence agency of a country which is federal in nature. You call it federal, you call it national, you call it central, it's the same thing. India's federal bank is the RBI. US's federal bank would probably be the US's Reserve Bank. Federalism does not mean powers of the states. Federalism means a country where you have the center and the states. That's it. So, a constitution will be either a constitution of a country which has twin layers or just has one layer. That's it. And if you compare the two, having twin layers is like having two children, siblings. So just think about it in this way. If you're a parent and you have two children and you have to distribute property, the will have to be more detailed. But if you just have one child, everything goes to that child. So unitary constitutions are constitutions of countries which only have one level of government. So all powers are with that government. There is no complication. Federal constitutions will always be more complex, will always be more detailed, which is why you will try to have a single written constitution in a federal country. If you have 10 different laws and all laws are equal and those 10 different laws are governing relationships between the center and the states, which law will prevail? What if law 1 contradicts law 2? Which is why you create a single comprehensive legal document called the Constitution and you say center-state relations are governed through this document. That is it. Governed through this document. Whatever the Constitution says about federalism, whatever the Constitution tries to talk to you about center-state division of powers, that is supreme. Otherwise, you will have one law on union list, second law on state list, third separate law on concurrent list. Everything is in one place. So while there are two different classifications, they're actually correlative to each other. Which is why they've also asked you this in the prelims exam. One of the features of a federal country is a written constitution. And a written constitution helps you be an efficient federal country. So your second level of classification is whether it is written in a single document or is it written in multiple documents. If it's written in a single document, it is called a written constitution. And the story doesn't end here. Because it is a written document in one document, it's in one document, you have to treat it specially. Otherwise, what will be the difference between the Constitution and any other law? So constitutional supremacy will happen only in cases where there is a written constitution. There's your prelims question right there. If you don't have a single law, how will you make it superior to all other laws? You want a federal country for which you need a written constitution. If you have a written constitution, you would want to make it supreme. You can only make it supreme if it is one document. Otherwise, there can never be two lions in a jungle. There can never be two constitutions in a country. Especially a country which has multiple stakeholders like the center and the states. So a written constitution therefore becomes the formal source of everything else. Every other law which governs the state will originate or will exist because the Constitution allows you to exist. Case in point, Representation of People's Act. The Representation of People's Act, in a sense, is constitutional law. It is governing the members who become elected. Representation of People's Act exists because an article in the Constitution very clearly says the Parliament can make so and so law. The Presidential and the Vice Presidential Election Acts of 1950 exist because an article allows you to exist. That is why we're a constitutional supremacy, not just that Article 13(2) exists. Whenever an article in the Constitution says the Parliament by law can make provisions on X, Y, Z, that is constitutional law. So a written constitution means a supreme constitution, means the formal source of all other constitutions. Now the question is, if I tell you you are special, you will ask me why, how am I special? If I tell you the Constitution is a supreme law, it can't be just that all other laws have to abide by it, or no other law can violate the Constitution. There has to be something else. If I tell you that the Constitution is supreme because no law can violate the Constitution, it's a very, very narrow argument, because it's negative in nature. That tomorrow, if there is a law which violates the Constitution will prevail. No. You're also supreme because we can change you differently. The process and the procedure to amend the Constitution will be different in a written Constitution, a single document. The supremacy of the Constitution is a twin concept. One, all other laws are subservient to it. It is the source of all other constitutional law. Second, it requires a special procedure to amend, which is why 368 exists. Article 368 serves a very simple purpose of upholding constitutional supremacy. Though this will never be asked in the prelims, but the entire Constitution is actually not supreme. The entire Constitution is actually not supreme. Only those parts against which a law can't be made. Fundamental rights are supreme. A simple practical example. Right to property is a legal right, we all know. It's also in the Constitution. So even for 1 second, I assume right to property is a constitutional right. Do we not have land ceiling laws? That's a straight violation. Which simply means, no doubt the Constitution is supreme. But within the Constitution also there is a higher degree of supremacy. However, this kind of intricacy is not important for the exam. Constitution is supreme is enough for prelims 2023 or beyond. So this is what makes us what we are. Sorry. And because the Constitution is supreme, judicial review becomes integral. If the Constitution is the supreme law of a country, all other laws which are enacted by the Parliament are secondary to the Constitution. Even the Parliament has a very limited role when it comes to the Constitution. The only way you can bring clarity to the Constitution is if the Supreme Court can interpret it. And how else will the Constitution be supreme? I'm saying the Constitution is supreme and no law can violate the Constitution. And who decides whether a law can violate the Constitution or not? The judiciary. So rule of law, independent judiciary, judicial review, written constitution, supremacy of the Constitution. It's one big conspiracy. They're all interrelated. You add a little bit of a masala of federalism on it. इसमें separation of powers जोड़ दो. How else will you have separation of powers if you don't have a single written document? Right? So India, UK, those are your basic differences. India is a written constitution. US is a written constitution. Australia is a written constitution. But UK is an unwritten. Singapore is a unitary constitution. India, US, these are all federal constitutions. In some countries, the center will be stronger than the states, like India. In some countries, the states will have a slightly more amount of powers, like the US. So India is a written constitution, also a federal constitution, but with a unitary bias. US is a written constitution, also a federal constitution, but with a federal bias. Where the states in the US have more functional power than the center. Again, you started your journey with rule of law. Rule of law, supremacy of the Constitution, principles of natural justice, judicial review, separation of powers, federalism, independent judiciary. These are all related to each other. And these are questions in the prelims exam. Clear? We have to be very careful with this. A question that is often asked and a question that should come to your mind is, why does UK, why does UK not have a written constitution? If they are the oldest democracy, why have they not written down a single document? If you notice, जब दिल टूटता है तो ही अकल आती है. All countries which have a written constitution have recovered from something traumatic. They would have seen a war, they would have recovered from colonialism, imperialism, there would have been social chaos. UK was the one causing the chaos. UK wasn't a victim of imperialism, UK was imperial. So they never felt the need to. Even US fought for independence, declared independence in 1776. You would want that one single document to be your guiding light because you've seen what happens when there is no order in chaos. And that's been a fundamental reason why. It doesn't mean that the UK doesn't have laws. In one single constitution of ours, we have fundamental rights. UK has Human Rights Act of 1998. That is their version of fundamental rights. In our constitution, we have dedicated articles for the Supreme Court. UK has a Supreme Court Act. We have provisions with respect to the Parliament and legislatures. UK has the Parliament Act. Do the exact same thing, but written in different formats. So the difference is, the UK Parliament can wake up tomorrow and repeal the Human Rights Act. The Indian Parliament can't do that. They could have if basic structure did not exist. They could have. There's nothing stopping. So that is the essence. Through a written constitution, you can create a larger control and limit the powers of the government. Which means there is a prelims question round the corner. In UK, is the parliament sovereign? Yes. Sovereign and supreme are almost the same thing. Sovereign means you don't have to listen to anyone. You're not bound by anybody's advice. You're free to do what you can. Is the UK parliament free to do whatever it wants to? Yes. India? No. The Indian parliament cannot do whatever it feels like. The constitution governs the Indian parliament. Is the Indian judiciary sovereign? No. Even the judiciary can only do what the constitution allows the judiciary to do. Which then brings a more fundamental question, is the constitution sovereign? There is no straight answer to this, which is why this can never be asked. Because if you read the preamble, people are the ultimate sovereign. वो लिखा है. This is why the one question the prelims exam cannot ask you, is the Constitution of India sovereign? Is the Constitution sovereign? There is no right or wrong answer. There can be an endless debate on this. But if you still have an itch that needs to be scratched, if your answer is, sir, what if it comes in the exam? Constitutional sovereignty means that the constitution is not bound by anyone. The parliament can amend the constitution, no? It cannot amend the entirety of it, but it can amend some parts of it. Everything which is not basic structure, the parliament can amend. The judiciary can technically interpret every provision of the constitution. There are very few things on which judicial review cannot happen. Maybe orders of a delimitation commission. Stuff in the 9th schedule which is not a part of basic structure. There are very few things the judiciary can't get into. Most things the judiciary can. Does that make the constitution sovereign? No. Because this is a philosophical debate. Our answer stops at, is the parliament sovereign? No. Is the executive sovereign? No. Is the judiciary sovereign? No. So who's the real sovereign? We the people. बस क्योंकि ये लिखा है. अपने को क्या करना है? रूल नंबर 1 लिखा है. बाकी ज्ञान done? Good. Now, just 1 minute on this. You would have studied the periodic table, ना? सोडियम को SO नहीं लिखते ना, Na लिखते. हाँ पे भी आदत डालना है. ये अभी से आदत डालना है क्योंकि जब मेंस लिखोगे यहाँ नंबर कटते हैं. The constitution is framed in a very, very logical manner. If there was an empty plot of land and each one of you had to be given 1 acre of a plot on that empty plot of land, the first thing you would do is decide your 1 acre and then decide who's going to stay. Then decide the people who are going to stay, what are the kind of privileges that they will enjoy. Then you're going to decide what more can you do for these people, but you can't guarantee. Then you will decide what are the responsibilities of the people towards you. That's part 1, 2, 3, 4. Territory, citizenship, rights, DPSP, duties. The Constitution is a formal legal document divided into parts. Parts are divided into chapters. Chapters into articles. Chapters का UPSC में कोई relevance नहीं है. याद करके कुछ नहीं उखाड़ो. Part 1, 2, 3, 4 आना चाहिए. समझ में आता. आर्टिकल थोड़े 1-2 मेंस में आता. But under sir chapter 13 sir, मेरे को भी नहीं आता. आर्टिकल्स के अंदर क्लॉज 19 clause 1 sub clause A. Sometimes there are provisos और explanation. जैसे वो freedom of religion में constitution में लिखा है कि कृपान्स are allowed. आर्टिकल में ही उन्होंने constitution में explanation लिखा है कि कृपान्स are allowed. So sometimes you'll have provisos or explanations within the article itself. ये सब कुछ फॉर्मल पार्ट है। प्रियम्बल इसलिए नहीं लिखा क्योंकि थोड़ा सा ग्रे एरिया है। एंड देन यू समटाइम्स, कॉन्स्टिट्यूशन है, फॉर्मल डॉक्यूमेंट है, फुटनोट्स भी होते हैं। सो योर अमेंडमेंट्स जो ऐड हुआ, जो डिलीट हुआ, द फॉर्मल टेक्स्ट ऑफ द कॉन्स्टिट्यूशन is available on a government website called legislation.gov.in. It's the Department of Law, department under the Ministry of Law and Justice. They update the constitution twice in a year, one in May and one in November. The official text of the constitution will always contain some footnotes. Minerva Mills is mentioned in the footnote. Quixote Zuluahan is mentioned in the footnote. That as per so and so judgment, this is rendered invalid. Because the Supreme Court has declared provisions invalid. Constitution में लिखा होता है. And then of course you have schedules. Schedules are essentially data sets. Remember, the relationship between schedules and everything else in the Constitution is the same relationship between universities and colleges. Universities can exist without colleges, but colleges cannot exist without universities. An article can exist without a schedule, but a schedule can never exist without an article. Every schedule under the title will mention the reference article also. Schedule 1 exists because of Article 1 and Article 80. Always. Every schedule will mention the reference article. They are all a formal text of the Constitution, including the preamble. All of these will be constitutional amendments. You amend a provision, you amend an explanation, you amend a text. Footnotes are explanations. Footnote में कोई amendment नहीं होता. ये तो हमको समझाने के लिए लिखा है. Everything except a footnote is the formal legal text. Amendment है. Now, whether it is an amendment under 368 or not, we'll figure this out later. But it's an amendment. Clear? Everything except footnotes are formal amendments to the Constitution. Under ordinary laws, सब कुछ सेम होता है, बस आर्टिकल की जगह सेक्शन बोलना है, बाकी सब सेम. International documents also we call articles. Article 1, 2, 3, 4 Kyoto Protocol. Article 5, 6, 7, 8 UDHR. 9, 10, 11, 12 ICCPR. International documents and constitution, articles, everything else, sections. Means में यहाँ नंबर कटते हैं. आर्टिकल आपको जैसे लिखना है आप लिखो. You write a capital ART, ARTICLE, that is up to you. But this is how it has to be done. Clear? Okay. Now that we've understood constitutions and constitutionalism is effectively about limiting state, we must broadly understand the kinds of state. There are two approaches to understand state systems. We only need to know one. The first approach is a political approach. The second approach is a politico-economic approach, where you classify states as, are they capitalist, are they socialist, are they communist? Because these are so abstract in nature, they are not legally defined, they will not be asked in the prelims. Maximum, when we are doing the preamble, and the preamble talks about socialism, I will give you a quick reference to the other formats. But what we are largely concerned with is the political manifestation or the political differentiation of state. First things first, state with a capital S is nation, country. Political science students will have a difference between nation and state. There will be a nation state theory for political science students. अपन लोग के लिए नहीं है, हम लोग खुश हैं, ठीक है? General studies, nation, state, country mean the same thing. State with a small s, province, federal province means the same. Clear? Now, from a political point of view, there are essentially three kinds of state systems. We're only concerned with one. First is monarchy, second is dictatorship, third is democracy. Dictatorship and monarchy are two sides of the same coin, peaceful and non-peaceful. The basic difference between democracy and any other two forms is participation and reflection of public will. That's it. So as UPSC aspirants studying for the prelims exam, do we need to know what monarchy is? No. Will the UPSC ever ask you which of the following is the most appropriate meaning of dictatorship? No. Monarchy simply means where there is an effective rule in place which is accepted but not reflected. Dictatorship is neither accepted nor reflected. Democracy is simple reflection of public will, participation of the people. अब वो kindergarten definition में नहीं जाना है. Democracy is government of the people, for the people, by the people. वो हमको नहीं लेना देना है. Remember, there are two kinds of democracies, direct and indirect. Direct democracies are like your ideas in economics. Heard of the kind of markets? Perfect competition, monopoly, है ना? Monopolistic, oligopoly. None of them exist in a real form. Absolute monopoly is an idea. It's an imaginative idea. Similarly, direct democracy simply means that the people are taking absolute decisions for everything. That is humanly not possible in a country. So we will have some variations of it. We will have some versions of it. We will try to get people decide on issues by themselves as much as is practically feasible. The difference between direct and indirect democracy is you finding a house by yourself or you getting a broker to do it for you. That's the basic difference. When you're finding a house for yourself, it is traumatic. It is a very long process. But the broker is your representative and is supposed to take care of your best interests. That is your indirect democracy. Pulling back focus on direct democracy, it simply means we as people, we as citizens, we will decide everything about our country. FDI policy आएगी या नहीं ये मैं डिसाइड करेगा. GST होगा कि नहीं कि मैं करेगा. Imagine 1.2 billion people every day deciding policy matters. Not feasible? So we will try to come as close as we can to this idealistic thought. From an institutional point of view, you would have heard of Gram Sabhas, right? Gram Sabhas are the closest that we come to a 360-degree direct democracy. You don't choose members of the Gram Sabha, you are members of the Gram Sabha. A Gram Sabha is simply a village parliament. You're not choosing members of the Gram Sabha. Everybody who's above the age of 18 in that village is automatically a member of the Gram Sabha. You automatically are. And within the powers of the Gram Sabha, they decide. मेरा इलेक्ट्रिसिटी का ये है, मेरा ड्रेनेज का ये है, सैनिटेशन के लिए मैं ये करूंगा, हेल्थ के लिए मैं ये करूंगा. If you travel to the hills, which I recommend after your prelims exam, if you find me there, don't come and say hi. Especially if my eyes are red. If you're crossing through Uttarakhand and Himachal and all of those, you'll see if you're crossing through these small little towns, you will see you have to pay 20 rupees to pass through that town. That's direct democracy. The Panchayat, the Gram Sabha of Palampur village has decided that everybody who passes through Palampur will have to pay 20 rupees. यही तो है direct democracy. You can't do this on a pan-India level. You go crazy. So what do? We try to give some versions of it. The abbreviation is R square IP. Referendum, Recall, Initiative, Plebiscite. Out of which referendum and plebiscite are related, initiative and recall are related. In general understanding, the collective term for referendum and plebiscite is referendum only. Referendum, plebiscite, initiative, they all come under the larger term called referendum. It all depends on the seriousness, who is conducting it, are you taking the outcome seriously, and what are you asking? All that you broadly need to know is a referendum is when the government asks a set of people, what do you want? And whatever the people say, the government agrees. Because the government has asked. It could be anything. It could be an opinion on a law. It could be whether they want to be a part of the country or not. It could be whether they think this practice should exist or not. It could be literally anything. But if the government is asking, it is a referendum. If anybody else is asking, it is a plebiscite. And plebiscites are usually questions on self-determination. Self-determination means, do you want to be a part of this country or not? The difference between a referendum and a plebiscite is that in the referendum, government asks anything. Plebiscite, anybody else asks, but only self-determination. That's the only difference. Both in referendum and plebiscite, the conversation is from somebody to the people. In initiative, it is the reverse. People go up to the government कि ये करो ना, इसको law बनाओ, ये act implement करो. Recall, or the right to recall as we understand it to be, कि इसको निकाल. When the people ask any public office to be removed, इंडिया में चारों का कोई फॉर्मल लॉ नहीं है. ये हम सब केस टू केस बेसिस पे करें. अच्छा लगेगा तो करेंगे, नहीं लगेगा तो नहीं करेंगे. India has had 6 successful referendums. 3 in 1947 and the rest after that. Goa, Pondicherry, Sikkim, these are all referendums. Accept kare na humne. The 3 that happened in 1947, Junagadh, Sylhet, around that time when they decided to live in India and not go to Pakistan. तो अगर प्री में नंबर नहीं पूछेंगे, प्री में पूछ सकते हैं, India has had at least 1 referendum. Yes. Or 5 referendum. Yes. We've had 6 referendum and 1 जो होते होते रह गया. Kashmir. It wasn't a referendum technically because the UN had to conduct it, and we had gone to the UN saying that if the UN comes to Kashmir, conducts a plebiscite under UN's supervision and asks the people of Kashmir in 1949 whether they want to be a part of India or they want to not be a part of India, and we are okay with this as long as the Pakistan army withdraws its forces from the places that they had infiltrated in. But Pakistan said 1 in hand is better than 2 in the bush. So they said nahi, ye chance nahi lenge, hum theek hain. And that never happened. Then India never agreed, because if you had conducted a plebiscite with Pakistani army infiltrated in Kashmir, it would have not been a fair plebiscite. And till today, Kashmir happens to be one of our longest standing conflicts, and that area that Pakistan had gotten into is today called Pakistan occupied Kashmir. We've had a minimum of 6 successful referendums. Do I need to know the names and details of them? No. But because prelims, they ask you these kind of questions. That at least one has happened. At least two has happened. Yes, they've happened. This is direct democracy. Indirect democracy is representative democracy. Direct democracy, participative democracy is the same thing. Indirect democracy is representative. You're choosing a broker. Now, depending on who are you choosing a broker. If you're choosing a broker who will choose a head broker, parliamentary firm. If you're choosing a main broker, presidential. Clear? Understood? Take. Very simply put, you have heard of two terms, head of state, head of government. Head of state is the person under whose name actions are taken. Head of government is the one who has the actual powers to undertake those actions. The first question you should have is, why do you have two different names? Because one of them is politically contingent. Head of government remains head of government till the time you have majority, till the time you have a mandate. Head of state has a defined tenure. So in a presidential setup, head of state and head of government is the same person. Has the UPSC ever asked you a prelims question on presidential form? Because India is not a presidential form. UPSC has always asked you what are the features of parliamentary form. प्री में क्यों पूछेंगे? मेंस में कभी पूछा है what are the advantages of presidential form of government? नहीं. मेंस ने पूछा compare the presidents of India and France. हाँ? Because अपना तो parliamentary system है ना. This is why PYQs are so important. This is why half the trash you study is not relevant. Syllabus इतना ही है. आधा तो फालतू है. So all we need to know for the prelims is features of parliamentary form of government. And the only feature that matters is that the executive is necessarily accountable to the legislature. And because India has twin legislatures, so the executive is collectively responsible to the direct legislature, to the Lok Sabha. Because if the Council of Ministers are also accountable to the Rajya Sabha, then the states would have a say in political stability at the center. And that would go against center stronger than the states. Simple logic hai. So in your prelims, all you need to do is find the option that says executive accountable to the legislature. Baki sab negotiable hai. Head of state and head of government are two different people because executive is accountable to the legislature. And head of state and head of government being two separate is not even a formal difference. A formal ideological difference between the parliamentary form of government and a presidential form of government is that the person who has the powers to execute and the person who makes laws are two separate. There's no connection at all. So no doubt presidential governments would be more efficient. The president has the absolute freedom in the US to choose whoever he or she wants to serve as a minister. But in India, you have to choose somebody who's an MP or will have to become an MP in 6 months. Because we believe in decentralization of power. And decentralization of power begins at the center. The first hallmark of decentralization of power is when you make it a parliamentary form. Because the power is within the parliament. The Lok Sabha decides whether the government exists or not. The US Congress can be dissolved, decapitated, dismantled. Nothing happens to the US president. That's not the case in India. The government loses majority, the government resigns. Nothing happens to the Lok Sabha, the government resigns, which again, by the way, is a factual inaccuracy in Lakshmikant. Lakshmikant says Lok Sabha dissolves on no confidence motion. Yes, it says that. It's incorrect. Lok Sabha does not necessarily dissolve on a no confidence motion. The only time a Lok Sabha in India compulsorily shuts down is after 5 years. That's it. After 2 years, no confidence motion passed, the president will decide whether I want a new government or not. Apply it to real time. If that was the case, when Indira Gandhi was assassinated, why didn't we have fresh elections? Why did we just change the prime minister? No, right? No. Resignation of the government has nothing to do with the dissolution of the Lok Sabha. A basic factual error, conceptual error. The Lok Sabha compulsorily shuts down only and only in one scenario, 5 years. That's it. That is it. Budget fails, money bill fails, Council of Ministers resign, koi baat. You can replace the government. Order of dissolution is not compulsory. Parliamentary form of government. The executive is accountable to the legislature, not the other way around. Understood? If the Lok Sabha had to compulsorily shut down every time the Council of Ministers resigned, would it not mean the opposite? That the Lok Sabha is dependent on the Council of Ministers? Yes or no? The Council of Ministers have been chosen because of the majority in the Lok Sabha. There is no majority in the Lok Sabha because of the Council of Ministers. You understand the difference? This is the only line that matters. Executive accountable to the legislature. This is why the Lok Sabha doesn't dissolve. The minister is accountable to the Lok Sabha, not the other way around. That's what makes a country system a parliamentary system. Of course, there are several other methods. Your entire ecosystem of parliamentary committees, disqualification frameworks, privileges, all of them emanate from executive accountability to the legislature. The third format, again not relevant for us in the prelims, is a semi-presidential form. थोड़ा सा इधर से, थोड़ा सा उधर से. Best of both worlds. Russia, Sri Lanka. President exists, also has real powers. Prime Minister exists, also has real power. Now apply a simple logic. Power is a concentration game, correct? Power is a simple concentration game. So if there is a country where both the president and the prime minister have real powers, and power is about being selfish, would you not give the president more powers? Yes? Why would you give the president any powers if the prime minister has more powers than the president? It is effectively parliamentary democracy then. That is why a combination is always called semi-presidential. Because power is a concentration matrix. ठीक है? पर अपन को यूपीएससी प्रीलिम्स में क्या लेना देना है? Parliamentary form. Democracy and elections are two very different things. Direct elections and indirect elections will exist in an indirect democracy. Direct election is you choose somebody, end of story. Indirect election is you choose somebody and they choose somebody else. We choose our MPs and MLAs, they choose the president. The president is an indirectly elected institution. Right? We choose our MPs choose the vice president is an indirectly elected institution. We choose our MLAs choose Rajya Sabha MPs are indirectly elected. Lok Sabha MPs are directly elected. Bas itta. Because when we pick up day after tomorrow legislatures, we'll begin with election frameworks. 15 मिनट में सिंपल डायरेक्ट इनडायरेक्ट प्रोपोर्शनल रिप्रेजेंटेशन सिंगल ट्रांसफरेबल होता क्या है बस ठीक है क्लियर for example when we will do this day after tomorrow in a presidential election we are aware that all legislatures all state legislatures the central legislatures and union territories with legislatures participate. Yes, Jammu and Kashmir doesn't because it's not in the law. In the constitution, it is mentioned in the election to the President of India, elected members of Lok Sabha, Rajya Sabha, elected MLAs of the states, not MLCs, and elected MLAs of Delhi and Pondicherry. They just forgot to mention J&K when they made J&K into a union territory with a legislature. It is a technical oversight. Yeah. But in our standard textbooks, it say all legislative assembly. The Constitution says Delhi, Pondicherry, legislative assemblies of all states, and Lok Sabha and Rajya Sabha. Despite being a union territory with legislatures, J&K doesn't. It's just a technical oversight. ठीक है? Done. Types are done. जल्दी से 5 मिनट में देश समझ लेते हैं फिर मेजॉरिटी समझ लेते हैं ये तो सबको आना चाहिए इतना तो पढ़ के ही बैठे हो यार. We've got 3 layers. I'll get off the board so that you can see this very clearly. 3 layers, the center, the states and local. We've got 3 branches, Brahma, Vishnu, Mahesh, legislature, executive, judiciary, creator, executor and destroyer or interpreter. At the central level, we've got 2 houses, bicameral, Lok Sabha and Rajya Sabha. Lok Sabha, as you can see, is direct election. We are choosing our Lok Sabha MPs, nobody else is. But it is an instrument of indirect democracy. They are going to be functioning on our behalf. Clear? Now, people in the Lok Sabha are called MPs. After the 104th amendment, we only have elected members in our lower houses. We do not have nominated members. इसका क्या मतलब हुआ? After the 104th amendment to the Constitution, if the center, if the Lok Sabha or any legislative assembly went into election and a new lower house was constituted, it would not have any provisions for nominated members to the Lok Sabha. Bas. So, for example, Bengal went into election after the 104th amendment. So, they don't have any nominated members in. Clear? Technically, right now also, we don't have. The Lok Sabha can have 2 Anglo-Indians, does not necessarily mean it has to. Understood this? But the 2024 elections that are going to happen, there will not be any provision in the first place. Do we understand the difference? A crucial one. Second chamber, Rajya Sabha. Rajya Sabha again is an instrument of indirect democracy and is indirectly elected. Rajya Sabha is elected by elected members of the respective states. Pre में formula नहीं आता है because it's a different version of a proportional representation. I'll tell you what it is anyways. That is your legislature. दोनों को MPs बोलते हैं. Executive two kinds of executive. What does the executive do? It implements. Now, there are two forms of executive: elected executive and permanent executive. Elected executive is Mantri, permanent executive is Babu. Babu, the one you want to become, not the one you have. UPSC is asked questions on what is the function of bureaucracy. This is the basic difference. बहुत ध्यान से सुनना, ये important है. Elected executive formulates policy. Permanent executive implements policy. बस इसके ऊपर की जितनी कहानी है वो प्री के लिए बकवास है. आया समझ में? इसके ऊपर जितनी कहानी है वो प्री के लिए बकवास है. We've seen previous year questions in the pre. The characteristic feature of bureaucracy is simple: to implement policy. So whichever option is the closest option to implementing policies, that is the right answer for bureaucracy. बस कुछ देखना ही नहीं है left right. ऐसे constitutionalism में what is it that we're looking for? Limiting power. Functions of bureaucracy, implementing. Functions of elected executive, formulating policy. ठीक है? Good. Now that we're talking about bureaucracy, you would have heard of a term called committed bureaucracy. क्या मतलब? वो पिछले साल पूछा था ना, which of the following is a problem? उसे committed judiciary करके एक ऑप्शन डाल दिया था और हम था परेशान हुई थी कि committed क्या? That is wrong. Sorry, Didi Bus. Sorry. So committed means they're good people. Then what does it mean? Think about it. We've seen previous year questions where they mentioned the word committed judiciary. ये तो देखा था ना, लास्ट ईयर ही पूछा था. तो committed bureaucracy क्या होता है? Committed to who? Committed मतलब ये तो आता ही होगा. Committed का मतलब बताता है. Committed to छोड़. हाँ? Very good. Excellent. You are committed to the exam? Good boy. Maybe committed to our parents? Partner also are committed to? Is that why you're wearing shorts? So when you are committed to your partner, what does that mean? Loyal. तो यहाँ अलग क्यों हुआ भाई? तेरा कमिटमेंट हमारा कमिटमेंट टिंडर. बात तो सही है वैसे. कौन लॉयल नहीं है? Committed bureaucracy is good. If bureaucracy is not committed, then you're in deep trouble. Bureaucracy has to be committed. Committed to whom? The people who appoint them. You guys are going to be civil servants, right? Who are you going to listen to? Janta? You're going to listen to the person who gives you the order. And the person who gives you the order gets the order from somewhere else. अच्छा लगे बुरा लगे, स्टेट सीएम के ऑफिस से फोन आया, पुतला लगाना है तो पुतला, what are you committed to? Bureaucracy. Bureaucracy will always be committed to the elected executive because they institutionally appoint and remove them. A non-committed bureaucracy is great for governance, terrible for democracy. If you guys were not committed, we would have already surpassed China. It is true. But you're bound in a democratic framework, correct? Committed judiciary is the problem. If the judiciary is committed to the executive, then you are in a reverse cycle. So committed judiciary is a threat. Committed bureaucracy is advantageous to parliamentary democracy. ये इंपॉर्टेंट टर्म था बताने। तो इसका मतलब ये हुआ कि अगर मैं ब्यूरोक्रेसी में लिखूं कमिटेड ब्यूरोक्रेसी तो वो सही है, बट कमिटेड जुडिशरी इज अ प्रॉब्लम. Judiciary cannot be committed. Judiciary committed to anything is a problem. How US judiciary is committed to justice. वो उसका काम है बाबा. I am committed to teaching. Clear? एग्जाम में आता है, ध्यान रखना. Then comes your Supreme Court at the top. ठीक है. States. ये I'll come to the judicial part of it. बोला ना अभी आते थोड़ी देर. पैसा दिया ना मैं, पढ़ा की जाए. Second layer we've got states and union territories, right? Now you've got three kinds of divisions at the second level: states, union territories with legislatures, union territories without legislatures. There are two kinds of states: states with double houses, states with single houses. Double houses are bicameral, single houses are, of course, happy states. Now, lower house of the states is a cut copy of Lok Sabha. Whatever happens there happens here in a smaller form. State Legislative Assembly is the Lok Sabha version at the states. But state legislative councils are not the Rajya Sabha version of the states. Rajya Sabha is compulsory. You cannot not have a Rajya Sabha. But you cannot have a state legislative council. Members of assemblies are called MLAs. Members of councils are called MLCs. Like the Lok Sabha, SLAs also do not have nominated members after the 104th amendment. Whereas the second houses of both the center and the states will have nominated members. Simple way to do this: LASS, LAS, Literature, Arts, Science, Social Service, Rajya Sabha. हम कहाँ बैठे हैं? Class. CLASS, SLC. Cooperative societies, literature, art, science, social service, state. Literature, art, science, social service, center. Lok Sabha nomination, LAS. SLC nomination, class. Why cooperative societies at SLC? Because cooperative societies is in the state list. इसलिए उनको दिया. ठीक है? Clear? ये एग्जाम में आ सकता है. Of course, बनते कैसे हैं, क्या है? When we'll do the legislatures, we'll do them in detail. बहुत आसान है. Resolution has to be passed by the state. The parliament may or may not agree, and after that you may create it, and you can also abolish it. Parliament decide करता है, state सिर्फ recommend. We'll come to. यहाँ तक clear हो गया? ठीक. Then you have your elected executive, you have your permanent executive. इसका structure मैं आपको detail में बताऊंगा, but वैसे collectively these are called ministers. चाहे center हो state हो, ministers. Everybody is a minister. ठीक है? अब बड़ा ministry का minister, a swarm of bees. सुना है ना? कलेक्टिव नाउन पढ़े थे? A sty of pigs, council of ministers. ये इंटेंशनल नहीं था, कलेक्टिव नाउन है ना? A house of flies, council of ministers. So collectively they are called ministers. ठीक है? And all said and done, jokes apart, if you are a learned minister, it's not easy running a ministry. You think bureaucracy is tough? Being a minister in the country is a completely different ballgame. Anyway, collectively, Council of Ministers. Minister of a big ministry, minister. Home, finance, agriculture. Minister of a small ministry, minister of state, independent charge. Second minister of a big ministry, minister of state. So you'll have a home minister and you'll have a minister of state home. You'll have an external affairs minister, you'll have an MOS state or MOS external affairs. Education minister, minister of state education. इसका मतलब ये नहीं हुआ फेडरल, junior minister. And smaller ministries can have ministers of state independent charge. जितना calculation करना है कर लो. The total number of ministers cannot be more than 15% of the total strength of the Lok Sabha. एक को 3 मिनिस्ट्री देनी है, 6 देनी है, 1 देनी है, 2 देनी है, आपके ऊपर. But the total number of ministerial allocations cannot be more than 15%. Everybody is in the council of ministers. उसमें से, because there are so many, so there is a form of indirect representation within the ministerial circle. वहां पे भी indirect democracy, उसको cabinet कहते हैं. So a smaller group of ministers who takes very key important decisions is called the cabinet. And they have cabinet committees. So cabinet committee on economic affairs, cabinet committee on security, cabinet committees on infrastructure, ये सभी है ना? That's it. This is also replicated at the state. ठीक है? Done. Closed. Permanent executive is also here. For prelims, chief secretary कौन है, कौन नहीं है, कोई जरूरत नहीं. 7 साल पहले पूछा था the chief civil services board के बारे में. कि cabinet secretary heads the civil services board. That is something that you would have anyways I deduced it without knowing it, because otherwise there's no end to it. ठीक है? Done. Now comes the tough part, the local. Both center and states, the entire representation here is indirect democracy. We've chosen somebody to do something on our behalf. That's not okay. That's not good. Because our idealistic notion of democracy is that the power to make decisions must be in our hand. We the people. Now, for geographical reasons, for practical reasons, we can't do this state-wise. We can't even do this at a national level. But what we can do is at the state. What we can do is at the state. Country divided into states, states divided into districts, districts divided into subdivisions, subdivisions divided into blocks, blocks divided into villages. कहानी इतनी इतनी simple कहानी. So at the local level, there are technically 4 divisions: district, subdivision, blocks, villages. इसमें से there is only subdivision which does not have any representative framework. इट्स अ प्योरली एडमिनिस्ट्रेटिव डिवीजन. बाकी डिस्ट्रिक्ट पे, ब्लॉक पे और विलेज पे इलेक्टेड रिप्रेजेंटेशन है. Some democratic institution exists. So we start right at the bottom, village. Now, if you're giving power to the people, should we not give power according to the sections in the people? अब रूरल और अर्बन लोकसभा तो नहीं बना सकते, रूरल और अर्बन लेजिस्लेटिव असेंबली नहीं बना सकते, बट कम से कम we can create rural and urban local legislatures. Why? Why do you need to create two separate legislatures based on rural and urban needs? Because the problems are different. है ना? हमारे यहां प्रॉब्लम है कि अनइंटरप्टेड इलेक्ट्रिसिटी नहीं है. वहां प्रॉब्लम है कि इलेक्ट्रिसिटी ही नहीं है. Do we understand the difference? हमारे यहां प्रॉब्लम है कि the stray animals are causing traffic. वहां प्रॉब्लम है कि कोई stray animal चुरा के ले गया. Yes? So if the problems are functionally different, then representations have to be different. We can afford to do this at the local level because we're dealing with a very limited geography. We're working with a very limited scope. तो इसलिए at the village level, और देखना अर्बन इंडिया में क्या एक्सेंट है, अंग्रेजी आती है क्योंकि अंग्रेजी आती है तो हम स्मार्ट हैं, ऐसा है नहीं. रूरल इंडिया नाम देखो कैसे सिंपल से. ग्राम सभा. ग्राम सभा इज नथिंग बट लोकसभा और असेंबली ऑफ द विलेज. The only difference is here you're choosing your MP, you're choosing your MLA, you are the MP or the MP. और कोई फर्क नहीं. The parliament exists as a whole. You don't choose the members, you are the members. Urban side अंग्रेजी नाम देना पड़ेगा ना, वार्ड. अंग्रेजी नाम देना पड़ेगा ना, वार्ड. सो अगर पार्लियामेंट है तो पीएम भी होना चाहिए, तो अगर ग्राम सभा है तो सरपंच होना चाहिए, सरपंच. बड़ा गांव है तो काउंसिल ऑफ मिनिस्टर्स होना चाहिए, ग्राम पंचायत. द सरपंच एंड द ग्राम पंचायत इज नथिंग बट पीएम एंड काउंसिल ऑफ मिनिस्टर्स ऑफ द विलेज. अब अर्बन इंडिया में फैंसी बोलना पड़ेगा. वार्ड चेयरपर्सन, वार्ड चेयरपर्सन आता उसको भी कुछ नहीं. The same thing at the block level. The parliament at the block level is called पंचायत समिति. अब अर्बन इंडिया इतना बड़ा है ही नहीं. 70% of India is rural, so it makes sense to have 3 layers. इतना सा तो अर्बन इंडिया है, उसमें आप 3 लेयर ही बना दो कि ब्लॉक ए राजेंद्र नगर 1, ब्लॉक ए बी का जिला, ABC का पूरा राज्य. If urban India is lesser, then you don't need 3 layers, you only need 2. So urban India only has 2 layers of local self-government. So the PM and COM of the blocks are called head of Panchayat Samiti and Panchayat Samiti Council. Then comes Jila. Rural India, Jila Parishad. Urban India, Municipal Council. Municipal Council, municipality, corporation, depending on the size. Head of जिला परिषद, जिला का रूरल पीएम, जिला का अर्बन पीएम, मियो. ये फर्क है बस. ये आपके सिलेबस में नहीं है. द परमानेंट एग्जीक्यूटिव ऑफ द लोकल सेल्फ गवर्नमेंट, ये प्री में नहीं आता कि कलेक्टर कहां लगते हैं, एसडीएम कहां लगते हैं. In this entire ecosystem, now what happens here is, in the permanent executive ecosystem, यहां हमने रूरल अर्बन डिवाइड किया, यहां पे भी कई बार हम रूरल अर्बन कर देते हैं. In fact, our permanent executive at the local level has two forms of classification: rural urban and civil and police is separated. As you go from top to bottom, the nature of powers will become more and more grassroots. Nuclear power is here. Imagine if you gave states nuclear power. कट्टा बना रहे बैठ के दिन भर, right? The more grassroots you go, the more local your power becomes. That is why it is SP in the rural part of the country and Commissioner of Police in the urban part, or ACP in the urban part. Civil administration generally remains neutral. आपका करियर शुरू होता है एसडीएम लेवल से, वैसे विलेज लेवल पे तहसील, ब्लॉक पे बीडीओ, एसडीएम, एसडीएम के ऊपर डीएम. हाउ यू हैव कैबिनेट सेक्रेटरी एंड अदर सेक्रेटरी, जैसे होम सेक्रेटरी, फाइनेंस सेक्रेटरी, एजुकेशन सेक्रेटरी. Here you will have chief secretary, home secretary, education secretary. You will not have a foreign secretary at the state. So DM also has secretary. उसको ADM बोलते हैं. There'll be an ADM land, there'll be an ADM law and order, there'll be an ADM development, there'll be an ADM general, there'll be an ADM welfare. So ADMs are nothing but secretaries of the DM or branches of the DM. SDM field posting होती है, DM field posting होती है, magisterial. ADMs work out of the collectorate only. SDM is DM of a subdivision. फिर एक तो आपको थोड़ा सा ब्रेक देते हैं सांस लेने का, फिर वापस. ठीक है, क्लियर? बस. Which then brings us to the third column, the two I's, independent and integrated. Are we completely independent and completely integrated? No. A degree of independence and a degree of integration. Matlab, we will appoint, the judiciary will appoint itself. That is their degree of independence. Independence means two things as far as the prelims exam is concerned. It can mean 10 things for the mains exam. But independence of judiciary means two things for the prelims exam. One, they can appoint themselves, at least the higher judiciary. Center and state is collectively higher judiciary. State and below is lower judiciary. So understand what this means in that context. Independence of judiciary means two things. One, they appoint themselves. Two, they can make their own procedures. That's it. In the prelims exam, if they ask you which of the following is the best characteristic of an independent judiciary, you're looking at two options. One, they effectively appointing themselves, and two, they are regulating their procedure. But this is also not absolute. Even the judiciary appointing themselves through the collegium system still requires presidential approval, which in effect requires the approval of the Council of Ministers. Which is why you will see several cases of collegium recommendations being sent back. Nothing is absolute. There's nothing called an absolute law. And two, the Supreme Court or any of the lower courts, high courts, can regulate their own procedure because the Parliament gives them the power to. The Constitution gives them the power to. So they are not functionally left away, because that would again be anti-democratic. And as far as integration is concerned, it simply means an application of the principle of judicial precedent, what we started our class with. You could start from the lowest court, go up to the highest court on appeal. You have a chain to follow. And judgments of the highest court are applicable to subsequent lower courts. This is integration. Will the prelims ever ask you a question on what is meant by integrated judiciary? No, because it is a very complex concept. Tribunals are a midpoint between the judiciary and the executive. तभी तो लड़ते रहते हैं. Executive बोलता है we are appointing our members so we should regulate. Judiciary बोलता है कि tribunals are performing a judicial function so we should regulate. That is what the entire drama around tribunalization is. Which is why you will see integrated judiciary is not a formal term used anywhere. Have you ever seen integrated judiciary being used anywhere? Independent. Integrated तो हमने चुपचाप चिपका दिया साथ में चलते चलते. There's no such thing. Yeah. There is no real such thing called integrated. It can't be also. Collegiums are, how many members in the collegium are required for Supreme Court? Total excluding the Chief Justice. 1 plus 4? Incorrect. No compulsorization. It's 1 plus 4 if on seniority. It's 1 plus 4 on seniority. The current collegium has more than 4 judges. By the way. Yep. Because of a seniority clash. Yes. वो तो सीनियरिटी में वैसे भी आएंगे. हाँ, बिल्कुल. The current Supreme Court collegium for choosing Supreme Court judges, as he very correctly said, very good, has 6 judges. Which is why in the prelims exam, have you ever seen an option that mentions the number of judges? This is why. Half the shit that we study is trash. It's not needed for the exam. आया समझ में? क्यों नहीं पूछते? क्यों हम क्यों रट के जाते हैं कि सुप्रीम कोर्ट कोलिजियम में 1 plus 4 क्योंकि वो डिफाइंड ही नहीं है. आज तक एक प्रीलिम्स का क्वेश्चन में नहीं आया क्योंकि वो डिफाइंड नहीं है. सीनियरिटी क्लैश होगी तो कोलिजियम बढ़ाना पड़ेगा. बस हाँ, a collegium comprising of senior most judges gives a recommendation to the president. That is correct. Seniority has 4 layers criteria, which we will study later. Number of years as a judge, number of years as a lawyer, date of enrollment in the bar, and then age, in that order. पढ़ते हैं, आता है मेरे को इसमें. Simplification is the toughest thing to do. The easiest is to make things complex. We're in the simplification business. ठीक है? अब आसान लग रहा है? बस. तो आधी चीजें तो पढ़ के ही नहीं जानी, इसलिए पॉलिटी में 90% क्वेश्चन सही होने चाहिए. चले? डन. majority. आज हालत टाइट लग रही सबकी थोड़ी. गुड. majorities. चलिए. ये थोड़ा ध्यान से, बहुत कॉन्सेप्चुअल है. दिस इज एक्सट्रीमली इंपॉर्टेंट. बहुत ध्यान से करें. ठीक है? Let's take an example of this class. There are about 200 students sitting in this class right now. Okay? The class is full. ऐसे YouTube में अच्छा भी लगेगा. But it is fully दिखा. हाँ, political rally नहीं है, सच्ची में full है. There are 200 students who have enrolled in this class. The total strength of this class is 200. Depending on the questions that I ask you, the strength would matter. अगर मैं बोलूं कि कल सुबह 6 बजे क्लास रखते हैं. It is something that is going to dramatically affect all the 200. So unless a majority of all the 200 agree, I will not shift the class timing to 6 a.m. 2, if I ask, can we lower the temperature of the air conditioning a bit? It will only affect the people who showed up to class tomorrow. If 10 people could not come or 10 people are delayed or 10 people said हमको नहीं आना हो गया मेरा जारी में, जो भी, correct? Whatever it could be, मैं जा रहा हो गया मेरा नहीं हो रहा, whatever. Signatory to the death penalty provisions in ICCPR. हम नहीं हटा रहे, तुम हटाओ, great. Capital punishment very bad. पर हमारे लोग देखें. Clear? So parliament में yes, no, मैं नहीं खेला. Abstain. Now, एक तो पहली बात, एब्सोल्यूट मेजॉरिटी, इफेक्टिव मेजॉरिटी, ये सब जितना भी नाटक है, सिंपल मेजॉरिटी, स्पेशल 1 2 3 4, ये हमारा बनाया है. In no prelims question will you see the words absolute, effective, simple or special. You will see the description. None of these words, absolute, effective, simple or special, are actually mentioned in the Constitution. वो डीडी बासु ने लिखा, लक्ष्मीकांत ने डीडी बासु का छापा, टीचरों ने लक्ष्मीकांत का छापा और पढ़ा दिया. ऐसे नहीं होता. We call it for convenience purposes, but these are not formally recognized. ये याद रखना. गलती से प्री में आ गया, as per the Constitution, absolute majority is this. As per the Constitution, absolute majority is nothing. So we start with the easiest. More than half of the total strength of the house. Total strength मतलब first day of our class today. कितने लोग उठ के बने हमारे एमपी? बाद में कुछ मरे, कुछ डिस्क्वालिफाइड, वो बाद में देखिए. बट कितनी ऑन डे 1 टोटल स्ट्रेंथ मेरे हाउस की कितनी? Absolute majority is only applicable in your lower houses because of collective responsibility. Remember parliamentary form? Lower house requires you to have a majority so that you can decide who do you want to make a minister. Whoever has a majority in the lower house will decide who the minister is going to be. The minister can come from either of the houses, that's all right. But the decision will be taken by somebody who enjoys the confidence of the lower house. And the confidence of the lower house is when you have established more than half of the total strength of the house. Only and only in lower house. सरकार बनानी है तो इतनी सीटें चाहिए, ये मतलब होता है. इसका और कहीं कोई यूज नहीं. तभी कहते हैं ना 273 मैजिक नंबर, 273 मैजिक नंबर. 273 is what? More than 50% of the total strength of the Lok Sabha. That's it. There is no other purpose of this. So it's in the Lok Sabha, it's in the state legislative assembly, and it is in the legislatures of union territories. 3 जगह लगेगा. Lok Sabha, legislatures of all states, and legislatures of union territory. Basically all lower houses. Then you move a little bit here. थोड़ा सा इस तरफ आ. Now we have to answer some tough questions. कि for example, मैग्ना कार्टा कैसा रहा? अगर मैं 5-6 दिन बाद आपको पूछूं, तो किसको पूछूं? जिन्होंने अटेंड किया ना. जो पहले दिन शक्ल देख के बोले नहीं नहीं ये तो कुछ आतंकवादी ही, उससे नहीं पूछूंगा ना। For your review of Magna Carta, you should have attended Magna Carta, correct? मैं आपका क्लास टीचर, मैं आपका क्लास मॉनिटर। तो पार्लियामेंट में क्लास टीचर और क्लास मॉनिटर कौन होता है भाई? कौन होता है? स्पीकर। Who's the class teacher, class monitor combo in the house? The speaker. Speakers का collective noun क्या है? Presiding officers. So all presiding officers, ठीक है? हाँ? Change in power 6 दिन बाद अपलोड होगा। अच्छा, तो 6 दिन जी लूं मैं, ठीक। So except the Vice President of India, because the Vice President is the Vice President and therefore the chairperson of the Rajya Sabha, not the other way around. The Vice President is the Vice President and because you are the Vice President, you are the chairperson. उल्टा नहीं है, that because you are the chairperson of the Rajya Sabha, you are the Vice President. Because ऐसा होता, so if 2 days the chairperson of the Rajya Sabha was on a holiday, the deputy chairperson became chairperson, वो जाके Vice President के घर में रह लेता कि अब तो मैं हलू, correct? Because लाइफ का गोल्डन रूल है, because you are an X, you are Y. बहुत डीप है, ठीक है? Because you are the Vice President of India, you are the chairperson राज्यसभा। तो उसको साइड रखते हैं। उसमें भी जिस हाउस का वो प्रिसाइडिंग ऑफिसर है, उसमें भी यही लगेगा। Because at the end of the day, the Vice President is the class monitor for Rajya Sabha, class teacher for Rajya Sabha only, no? Then, so what is effective majority? Apply it to your classroom. For me to ask your review on Magna Carta, those of you who've been a part of the class will be asked. It will also be unfair कि 6 दिन में से 1 दिन नहीं आई तो आपसे नहीं पूछूंगा, वो भी आपके लिए unfair है। You should have been a part of it. Now apply this. Why would you not be a part of it? Either you withdraw कि मेरे को नहीं करना Magna Carta, या मेरे को एग्जाम ही नहीं लिखना, जो भी है। Why would somebody not be a member of the house? या तो मर ही गया, या खुद ही रिजाइन कर दिया, या निकाल दिया। So from the total strength, if I remove the people who are dead, if I remove the people who are disqualified, I remove the people who have resigned, I have what is called the true strength of the house, the strength that was meant to be. उनसे पूछूंगा ना कि स्पीकर सही आदमी है कि नहीं? Yes? So more than half of that. See, if I have to remove the Vice President and 90% of Vice President's job is to manage the Rajya Sabha, I will use the same majority in the Rajya Sabha to remove the Vice President. But because he is the Vice President, Lok Sabha से भी पूछ लेंगे, because थोड़ी बड़ी हस्ती है। But for everybody else, all presiding officers of all legislatures, center state, except the Vice President, उसमें भी ये partially लगता है, will be removed through effective majority. Will be removed through effect. ये golden principle समझ में आ गया? तो हमको याद नहीं करना पड़ेगा। All presiding officers fully and Vice President partially removed through effective majority. Effective majority is nothing but total strength minus number of people who have died, disqualified or resigned. अब भूत से थोड़ा ना पूछूंगा मैग्ना कार्टा कैसा था? Yes? वो तो डिस्क्वालीफाई हो गए ना, अब उनसे क्या पूछूं कि लोकसभा स्पीकर को रखना है कि नहीं? समझ रहे हैं किनकी बात कर रहा हूं? जिनको ठंड नहीं लगती। क्लियर? पक्का? Then comes simple majority. It is so simple, they call it simple. जितने आए हैं उनमें से पूछ, more than half of present and voting. बस. There's something special about simple majority. ये आपकी default majority. अगर नहीं लिखा है कौन सी majority है, if it's not explicitly mentioned what kind of a majority, you will assume it to be a simple majority. Everything that happens on the floor of the house, all parliamentary processes except resolutions, उसमें भी 2-3 टाइप के, but major parliamentary process, simple majority. Just look at the irony. You require an absolute majority to form government and you require a simple majority to break government. If this is not executive responsibility to legislature, then I don't know what is. Do you now understand why do we have a cheaper majority to make the government fall? Because of a fundamental principle of parliamentary democracy, the executive is responsible to the legislature. It may take you all the hard work to get those numbers to form government. But even if more than half of the people who are sitting in the house on a fine day, and at least 10% have to sit, quorum, bas. So the quorum for Lok Sabha is 55, 54, 545 ka 1/10 is 55. It takes 55 members in the Lok Sabha to topple a government. It takes 270 to form one. Executive responsibility to the legislature. So all laws, और बहुत simple है, anything which is not an amendment to 368, you are making a law, changing a law, deleting a law, adding a law, subtracting a law. Anything which has nothing to do with Article 368 enabled amendments, or any law which is not an amendment under Article 368, center state doesn't matter, simple majority. See the simple majority. 270 लोग लगे सरकार बनाने में, but a simple majority can defeat your budget. You require a simple majority to pass it, with of course a 10% minimum attendance. Okay? So simple majority has two basic functions. One, any law which is not an amendment under 368, and it is your default majority. No confidence motion, any election that happens on the floor of the house, anything, any house related, simple majority. अगर कहीं और नहीं लिखा है, आप assume करेंगे simple. No confidence, censure, adjournment, election of speaker, right? Sorry. Election of speaker, all of this is simple. Okay? Unless otherwise mentioned, this is your largest used majority. Then we have 4 special majorities. The basic difference here is, the basic difference between this side of the graph and this side of the graph is, यहां थोड़ा सेंटर स्टेट का मामला है. कुछ ना कुछ, कहीं ना कहीं, किसी ना किसी तरीके से will affect center state, will affect the ecosystem of federalism. And this is in an ascending order, easy to tough. This was in a descending order, tough to easy. That's why the graph is a V-shaped graph. So the first is more than 2/3 of present and voting, which is slightly more than simple. Simple was more than half of present and voting. So we are simply moving from 50% plus 1 to 66% plus 1. This is a resolution majority. But not all resolutions. Special resolutions. Resolution क्या होते हैं? Teach you in legislatures. But for example, Rajya Sabha has some special powers to authorize the parliament to make a law on the state list, to authorize for any changes to all India services. Yes, इन दोनों में federal implication है. If you are allowing the parliament to make a law on something which is exclusive to the states, you are literally opening federal balance into half. And if you are making a changes to all India services what? Recruited by the center, removed by the center, but they work at the states. You're recruiting a set of people who are going to compulsorily be working at the states, and the states can't reject them. You are all India service, right? IAS, IPS and forest. Can the state say हमको नहीं चाहिए? रखना पड़ेगा. Yes? There's a federal implication. When the state legislative assembly passes a resolution begging the parliament for a council, that's a federal implication. हम एक सेंट्रल अथॉरिटी को बोल रहे कि हमको दूसरा हाउस बनाने को दे दो. This is where it is. It is used for special resolutions of the Rajya Sabha, and it is used for special resolutions of the Assembly. बस इतना ही. So this is only and only in the Rajya Sabha and very limited in the state legislative assembly. More than 2/3 of present and voting. Then you have the second. Now there is a big confusion, a big factual inaccuracy. More than 2/3 of present and voting and more than half of the total strength. These are two separate rounds. If you are the Lok Sabha and you're using this majority, so first, more than 2/3 of you present and voting have to agree. Then I will ask you the same question again. Then more than half of the total strength also has to agree. आया समझ में? In a different order, whatever it is. So special majority 2 again is a dual counting majority. एक ही सवाल आपसे 2 बार पूछा जाए. Yes, oh yes, but in a different. Clear? And this is used only and only in the upper houses. Only and only in the upper houses. Either to pass a certain kind of amendments under 368 or to remove some constitutional body. सुप्रीम कोर्ट हाई कोर्ट जज को निकालना है, सीएजी को निकालना है, तो ऐसा लगे. और a certain kind of amendments. क्यों? Why do you require a majority like this to remove a Supreme Court or a High Court judge? Because they have federal implications. Remember, judiciary is directly related to federalism. We spoke about it. So if you're removing instruments of judiciary, you're affecting federalism. Are you not? Yes. Why do you think we're using this majority to remove Supreme Court, High Court judges? Because they also play a federal role. Except, and I'm just digressing for 30 seconds, a very common misconception in our country is that the Supreme Court is all powerful. It is. But if you take the original jurisdiction away from the Supreme Court, which is to look into disputes of the center and the states, the High Court and the Supreme Court pretty much do the same thing. They pretty much do the same thing. Maybe the High Courts have a little wider role to play because of 226. If I take center-state disputes away, the high courts are as good and as magnanimous. Everything that the Supreme Court can do, the High Court can do. The Supreme Court can strike down a central law. The High Court can strike down a central law. You can challenge a fundamental right in Supreme Court. You can challenge a fundamental right in High Court. Will it not have a federal implication? Yes. Of course it would. Then the third majority that we use, special majority 3, is a twin layered majority. It will require special majority 2 in the upper houses and simple majority in the lower houses. It is only and only used in one case. Special amendments under Article 368. There are two kinds of amendments under Article 368. One which require the states to participate, one which do not require the states to participate. I'll show it to you in the next slide. So the ones which require the states to participate, this is the process. First, the law will be passed independently by both the houses at the center using special majority 2, where they will vote twice. So Lok Sabha, Rajya Sabha will vote twice in their own houses, more than half of total strength and more than 2/3 of present and voting. Ye ho gaya. Then it will be sent to all state legislatures and legislatures of union territories, by the way. So all regional legislatures. And out of all regional legislatures, at least half of them have to pass the same through simple majority. We've got 28 states. We've got Delhi, we've got Pondicherry, we've got JNK. So 28, 29, 30, 30. Out of 31, at least 16 regional legislatures should pass the same amendment that the center has passed, but using simple majority. Okay? So this takes care of your majority. GST bill will be an example. Yes, absolutely. Pakka? And the final majority again is only used in one case, that is to abolish the president, to impeach the president. So, abolish. आप देख रहे हो इतनी इनकंसिस्टेंसी, सुप्रीम कोर्ट हाई कोर्ट जज निकालने के लिए more than 2/3 present and voting and more than half of totals हो जाएगा. सरकार गिलाने के लिए सिंपल majority. फिर कॉन्स्टिट्यूएंट असेंबली को बाद में चमका कि ओहो ये तो गलती कर दी. This provision is a saving grace. The toughest majority, more than 2/3 of total strength. More than 2/3 of total strength. Only in the central houses and only to remove the president. Bas or koi use. So special majority 3 and special majority 4 just have a single use. To special majority 3 only to pass a specific kind of amendments under 368. Special majority 4 to impeach the president. Special majority 2 has multi-dimensional functions. You may be using it to remove some offices. You may be using it to pass some laws. Special majority 1 has, again, it's a resolution majority but used in 2 different places. Simple majority is the most diverse. Effective also has just one purpose and absolute also has just one. Okay? Everybody is clear with majorities? If you're clear with majorities, then we quickly move to applying these majorities. Job is to manage the Rajya Sabha. I will use the same majority in the Rajya Sabha to remove the Vice President. But because he is the Vice President, Lok Sabha se bhi पूछ लेंगे. Because थोड़ी बड़ी हस्ती है. But for everybody else, all presiding officers, of all legislatures, center state except the vice president, उसमें भी ये partially लगता है, will be removed through effective majority. Will be removed through effect. ये golden principle समझ में आ गया? तो हमको याद नहीं करना पड़ेगा. All presiding officers fully and vice president partially removed through effective majority. Effective majority is nothing but total strength minus number of people who have died, disqualified or resigned. अब भूत से थोड़ा ना पूछूंगा मैग्ना कार्टा कैसा था. Yes? वो तो डिस्क्वालीफाई हो गए ना. अब उनसे क्या पूछूं कि लोकसभा स्पीकर को रखना है कि नहीं. समझ रहे हैं कि इनकी बात कर रहा हूं, जिनको ठंड नहीं लगती. क्लियर? पक्का? Then comes simple majority. It is so simple they call it simple. जितने आए हैं उनमें से पूछ. More than half of present and voting. बस. There's something special about simple majority. ये आपकी default majority. अगर नहीं लिखा है कौन सी majority है, if it's not explicitly mentioned what kind of a majority, you will assume it to be a simple majority. Everything that happens on the floor of the house, all parliamentary processes except resolutions, उसमें भी 2-3 टाइप के, but major parliamentary process, simple majority. Just look at the irony. You require an absolute majority to form government and you require a simple majority to break government. If this is not executive responsibility to legislature, then I don't know what is. Do you now understand why do we have a cheaper majority to make the government fall? Because of a fundamental principle of parliamentary democracy, the executive is responsible to the legislature. It may take you all the hard work to get those numbers to form government. But even if more than half of the people who are sitting in the house on a fine day, and at least 10% have to sit, quorum, bas. So the quorum for Lok Sabha is 55, 54, 545 ka 1/10 is 55. It takes 55 members in the Lok Sabha to topple a government. It takes 270 to form one. Executive responsibility to the legislature. So all laws, और बहुत simple है, anything which is not an amendment to 368, you are making a law, changing a law, deleting a law, adding a law, subtracting a law, anything which has nothing to do with Article 368 enabled amendments, or any law which is not an amendment under Article 368, center state doesn't matter, simple majority. सीधा simple majority. 270 लोग लगे सरकार बनाने में, but a simple majority can defeat your budget. You require a simple majority to pass it, with of course a 10% minimum attendance. ठीक है? So simple majority has two basic functions. One, any law which is not an amendment under 368, and it is your default majority. No confidence motion, any election that happens on the floor of the house, anything, any house related, simple majority. अगर कहीं और नहीं लिखा है, आप assume करेंगे simple. No confidence, censure, adjournment, election of speaker, right? Sorry, election of speaker, all of this is simple. ठीक है? Unless otherwise mentioned, this is your largest used majority. Then we have 4 special majority. The basic difference here is, the basic difference between this side of the graph and this side of the graph is, यहां थोड़ा सेंटर स्टेट का मामला है. कुछ ना कुछ, कहीं ना कहीं, किसी ना किसी तरीके से will affect center state, will affect the ecosystem of federalism. And this is in an ascending order, easy to tough. This was in a descending order, tough to easy. That's why the graph is a V-shaped graph. So the first is more than 2/3 of present and voting, which is slightly more than simple. Simple was more than half of present and voting. So we are simply moving from 50% plus 1 to 66% plus 1. This is a resolution majority. But not all resolutions. Special resolutions. Resolution क्या होते हैं? Teach you in legislatures. But for example, Rajya Sabha has some special powers to authorize the parliament to make a law on the state list, to authorize for any changes to all India services. Yes, इन दोनों में federal implication है. If you are allowing the parliament to make a law on something which is exclusive to the states, you are literally opening federal balance into half. And if you are making a changes to all India services what? Recruited by the center, removed by the center, but they work at the states. You're recruiting a set of people who are going to compulsorily be working at the states, and the states can't reject them. You are all India service, right? IAS, IPS and forest. Can the state say हमको नहीं चाहिए? रखना पड़ेगा. Yes, there's a federal implication. When the state legislative assembly passes a resolution begging the parliament for a council, that's a federal implication. हम एक सेंट्रल अथॉरिटी को बोल रहे हैं कि हमको दूसरा हाउस बनाने को दे दो. This is where it is. It is used for special resolutions of the Rajya Sabha, and it is used for special resolutions of the Assembly. बस इतना ही का. So this is only and only in the Rajya Sabha and very limited in the state legislative assembly. More than 2/3 of present and voting. Then you have the second. Now there is a big confusion, a big factual inaccuracy. More than 2/3 of present and voting and more than half of the total strength. These are two separate rounds. If you are the Lok Sabha and you're using this majority, so first, more than 2/3 of you present and voting have to agree. Then I will ask you the same question again. Then more than half of the total strength also has to agree. आया समझ में? In a different order, whatever it is. So special majority 2 again is a dual counting majority. एक ही सवाल आपसे 2 बार पूछा जाए. Yes, oh yes, but in a different. Clear? And this is used only and only in the upper houses. Only and only in the upper houses. Either to pass a certain kind of amendments under 368 or to remove some constitutional body. सुप्रीम कोर्ट हाई कोर्ट जज को निकालना है, सीएजी को निकालना है, तो ऐसा लगे. और a certain kind of amendments. क्यों? Why do you require a majority like this to remove a Supreme Court or a High Court judge? Because they have federal implications. Remember, judiciary is directly related to federalism. We spoke about it. So if you're removing instruments of judiciary, you're affecting federalism. Are you not? Yes. Why do you think we're using this majority to remove Supreme Court, High Court judges? Because they also play a federal role. Except, and I'm just digressing for 30 seconds, a very common misconception in our country is that the Supreme Court is all powerful. It is. Of course it would. Then the third majority that we use, special majority 3, is a twin layered majority. It will require special majority 2 in the upper houses and simple majority in the lower houses. It is only and only used in one case: special amendments under Article 368. There are two kinds of amendments under Article 368, one which require the states to participate, one which do not require the states to participate. I'll show it to you in the next slide. So the ones which require the states to participate, this is the process. First, the law will be passed independently by both the houses at the center using special majority 2, where they will vote twice. So Lok Sabha, Rajya Sabha will vote twice in their own houses, more than half of total strength and more than 2/3 of present and voting. Ye ho gaya. Then it will be sent to all state legislatures and legislatures of union territories, by the way. So all regional legislatures. And out of all regional legislatures, at least half of them have to pass the same through simple majority. We've got 28 states. We've got Delhi, we've got Pondicherry, we've got JNK. So 28, 29, 30, 31. Out of 31, at least 16 regional legislatures should pass the same amendment that the center has passed, but using simple majority. Okay? So this takes care of your majority. GST bill will be an example. Yes, absolutely. Pakka? And the final majority again is only used in one case, that is to abolish the president, to impeach the president. So, abolish. आप देख रहे हो इतनी इनकंसिस्टेंसी, सुप्रीम कोर्ट हाई कोर्ट जज निकालने के लिए more than 2/3 present and voting and more than half of total हो जाएगा. सरकार गिलाने के लिए सिंपल majority. फिर कॉन्स्टिट्यूएंट असेंबली को बाद में चमका कि ओहो ये तो गलती कर दी. This provision is a saving grace. The toughest majority, more than 2/3 of total strength. More than 2/3 of total strength. Only in the central houses and only to remove the president. Bas or koi use. So special majority 3 and special majority 4 just have a single use. To special majority 3 only to pass a specific kind of amendments under 368. Special majority 4 to impeach the president. Special majority 2 has multi-dimensional functions. You may be using it to remove some offices. You may be using it to pass some laws. Special majority 1 has, again, it's a resolution majority but used in 2 different places. Simple majority is the most diverse. Effective also has just one purpose and absolute also has just one purpose. Okay? Everybody is clear with majorities? If you're clear with majorities, then we quickly move to applying these majorities. इस देश में 2 तरह के कानून हैं. Supremacy of the law पढ़ा था, and we understood what is more supreme than the law. The Constitution. So we are a supremacy of law, rule of law, but within rule of law, constitutional supremacy. And what was one of the special hallmarks of constitutional supremacy? That you will treat the law specially. You will treat the law specially. You will create some special procedure for it. Bas. And we also understood that the entire constitution can't be treated specially. It's too big of a document. It is too diverse of a document. So we cannot do that. It will not be all right. It will not be comfortable. So what do we do then? We divide our applications of majorities. Okay? Either you're changing the constitutional provisions, or you're making a change in any other law, bringing any other law, replacing any other law which is not the Constitution. Can you change the entire Constitution as a whole? No. No. Because Article 368 stops you from doing. So if there is a hypothetical question in your minds, can we replace the entire Constitution at once? The answer is no. There shall always be a Constitution. There can never be a case where there is no Constitution of India, even if it is for a second. You can change provisions in box and places and in truncheons, but you cannot replace the Constitution once and for all. Which means you can change provisions, remove, delete, add, subtract, but the entire legal document as a whole remains there. That's not the case with any other. Central law, state law, civil law, criminal law, private law, public law, doesn't matter. Everything else which is not the Constitution. And now within the Constitution, उसमें भी हमने हायरार्की बनाई कि एक तो दिल्ली ऊपर से साउथ दिल्ली. So the South Delhi of Indian Constitution is Article 368. और साउथ दिल्ली भी नहीं, साउथ दिल्ली में जोरबाग, golf links, can't mark it. So within 368 there are two special ramifications. Article 368 tells you two different ways to change two different types of constitutional provisions. ठीक है? पहली बात तो अगर आर्टिकल 368 पे मेंशन नहीं तो बात ही खत्म. Then तो it doesn't matter. Anything which is any other law or any change to the Constitution not referenced to 368, simple majority. Simple. बात ही खत्म. Simple majority. Provision में लिखा होगा that an amendment to this article will not be considered an amendment under 360. जैसे आर्टिकल 4 में लिखा है that an amendment to provisions pertaining to territory will not be considered a constitutional amendment under 360. या तो कॉन्स्टिट्यूशन में दो बातें लिखी हूं. Either it will be very clearly written it is not to be considered an amendment under 368, or it will be written that it requires special majority 3. Either it will be written, Article 368 will tell you the following things require special majority 3. Provisions in the Constitution will tell you that specifically not to be considered an amendment under 368. बाकी जो बचा special majority 2. What I'm trying to say, थोड़ा सा confusing लग सकता है. What I'm trying to say, special majority 2 हमारे constitutional amendments की default majority. अब समझ में आया? either that provision would be mentioned under 368 or it will be written in that provision that this is not to be considered under 368. अगर ये दोनों में से applicable नहीं है तो special majority, which is essentially without state ratification. So we understood that all this special majority requires a federal impact. Now if it's a federal impact with state ratification, तो कितना ही federal impact हो रहा होगा? It would be another level of a federal impact. Yes or no? So for exactly those purposes, we have these things. If you change the way the president is getting elected, you're affecting states, not only in terms of the election. The president has the powers to impose state emergency, bhai. If you're changing the powers of the center and states, इससे ज़्यादा क्या affect करे? This is why GST. If you're changing the appointment and the powers of the Supreme Court and appointment and removal of the Supreme Court or High Courts. Remember NJAC, the National Judicial Appointments Commission? It was a constitutional amendment which required state ratification because it was changing the appointment and removal of Supreme Court and High Court. In सब में क्या है? Aggressive federal impact. Federalism reloaded. The return of the federal saga. And अगर Article 368 ही बदलना हो, हमको हमी से चुरा. Changes to 368 will also require state ratification. ठीक है? So actually Article 368 talks about special majority with state ratification. Otherwise, every specific provision will have it. Like for example, if you're amending the constitution to create a legislative council, not an amendment under 368. If you're creating a new state, you will amend Schedule 1, not an amendment under 368. But अगर Article 21 में 21A add करेंगे तो it is an amendment. Think about it. इसको logically सोचो. I am adding Article 21A. Is it affecting the Constitution? Yes or no? Yes or no? Yes. It's affecting the Constitution. Is it somewhat serious or not very serious? Serious. Is it aggressively federal or not aggressively federal? Not aggressively federal. Aggressively federal मतलब चार चीजें होनी चाहिए. President, Judiciary, Center State Powers, 368. नहीं है तो aggressively federal नहीं. और कहीं गलती से लिखा है 21 में that an amendment will be not considered an amendment under 368. सारी केशवानंद भारती की तो लड़ाई इसी पे थी. Yes. So Article 21A inserted by which constitutional amendment? 86 Constitutional Amendment 2002 was a constitutional amendment under 368 without state ratification. Bas. National Judicial Appointments Commission was an amendment to the Constitution under 368 with state ratification. Bifurcation of Uttar Pradesh into Uttar Pradesh and Uttarakhand was an amendment to the Constitution outside Article 368. इसको हम Constitutional Amendment ही नहीं कहते, Act ही बोल के इनकी बेइज्जती कर देते कि लायक ही नहीं हो तुम संवैधानिक संशोधन कहलाने के. Clear? Then comes the other laws. There are multiple ways to classify these laws, but the only procedural difference lies with these three. Article 370, 377 to section. I can understand the confusion. Excellent question. The question hurt me. I'll answer. He's got a good question. He says, sir, Article 370. पहली बात, Article 370 has not been touched. It is still there. It is like the appendix. अब वो वेस्टिजल हो गया, वो ऐसे लटक रहा है, ऐसे कोई काम नहीं उसका. Now let me tell you what it is. बहुत ध्यान से सुनना. You will answer my question by answering your question. Welcome to Inception. Everybody can participate. You will be amazed at the answer. अब लास्ट पार्ट, ठीक है. दिवाली है. 3 choices will be given to you. Choice number 1, let us reorganize the furniture of our house. पैसा लगेगा? नहीं लगेगा ना. You will just. Choice number 2, let us repaint the furniture of our house. पैसा लगेगा, लेकिन will we get new furniture? Choice number 3, let us buy new furniture for the house. पैसा लगेगा, नया कुछ आएगा. That's the difference, ladies and gentlemen, between ordinary money and finance. यही है ना. बस क्यों कॉम्प्लिकेट करना. But sir, Article 110 so withdrawal from so. But सीधा बात कर. New idea which does not require money, original bill. An idea which only requires money bill. And a new idea which requires money, financial bill. तो अब मेरे को ट्रिपल तलाक क्रिमिनलाइज करना है. पैसा लगेगा. किसी को क्राइम करने के, do you require money to declare something a crime? नहीं, मैं डिक्लेयर किया कि क्राइम. मैं डिक्लेयर किया कि क्लास में शॉर्ट्स पहन के आना क्राइम है. पैसा लगा नहीं है कोई. जेन्युइनली मैं तेरी जगह जब मैं पढ़ता था इधर ही बगल में बड़ा वाला, वहीं पढ़ा वहीं पढ़ाया. I am the definition of what is called PPO, pre-placement offer. Studied in Vajiram, taught at Vajiram for 8 years. I hope आपके साथ ये ना हो. मैंने कहा ओहो पैसा तो वापस लेना पड़ेगा. ठीक है. Anyway, मैं भी ऐसी क्या बोल रहा था. कोई चीज को क्राइम डिक्लेयर करने के लिए पैसा नहीं लगता ना. ठीक. मेरे को एमपी का सैलरी बढ़ाना. मैं नया एमपी लेके आया, नया पैदा किया. एग्जिस्टिंग एमपीज का 5,000 रुपए बढ़ा दिया मैं. Am I getting new MPs? No, right? Money bill. But if I increase the strength of Supreme Court judges, if I increase the strength of Supreme Court judges from 31 to 34, am I getting new Supreme Court judges? पैसा लगेगा? वैसे नहीं, सैलरी में लगेगा. हाँ, financial bill. बस. But sir, what about financial bill A and B? So लक्ष्मीकांत में लिखते category 1 and category 2. The official classification is financial bill category A, category B. एक में पूछ के इंट्रोड्यूस करते, एक में नहीं करते. मैं बता दूंगा, बट ब्रॉडली यही है. बस. अब कोई कानून उठा लो, कोई मेजॉरिटी उठा लो, कुछ उठा लो, इसमें यही हुआ ना. हो गई आधी पॉलिटी. Genuinely, your majorities are done, applications are done, legal structures are done, खत्म. प्री में तो इतना ही पूछते हैं बस. ठीक है. So this covers A. Oh. Now, ये fresh कर, ये मेरा punchline, ये masterpiece. Tomorrow we'll start at 11:30 sharp. 11:30. That thankfully we are doing only preamble, fundamental rights, DPSP duties tomorrow, right? यही कर रहे हैं ना? कल का ऑफिशियल स्लॉट यही है ना? तो 11:30 to 12:30 ये और प्रियम्बल ये और टेरिटरी सिटीजनशिप खत्म करते हैं. 12:30 to 1:30 प्रियम्बल खत्म करते हैं. फिर 2 to 4:30 5 तक खींच के राइट्स डीपीएसपी ड्यूटी खत्म करते हैं. बहुत आसान है, कुछ है नहीं. डन? ठीक है, समझ में आया? मजे आए? क्लियर हुआ? कल लेट नहीं करना, 11:30 शार्प. ठीक है? Today we started 5 minutes late because you guys were figuring out, because apparently this is an undiscoverable location. Okay. We start today's session with what is perhaps the most important part of Magna Carta. The purpose of these golden rules is twofold. One, it helps you cross-check the answers that you're going to mark anyway. And two, when you don't know what the answer is, this is the best way to take an educated guess to get your questions right. And whether we like it or not, you have to take those educated guesses in the exam. No matter how great your preparation has been so far, there is nobody in this country who's writing the prelims exam who will know a maximum of more than 40 questions sure shot. 45 in a best case scenario. That still gets you to about 90 marks. We need 110. Whether you like it or not, you will have to make good educated guesses for at least 10 to 20 questions. And polity becomes one of those areas where your educated guesses have a very high accuracy. So we have to get those right. This is nothing but based on constitutional principles. There are 4 rules. Some of you may be knowing all of these. It may be a refresher for you. For those of you who don't, this will change the way you look at polity. The first rule is called democratic mandate. Yesterday, we discussed that the principle of democracy is representation of will or representation of public will. Let us now bring it to something usable. Democratic mandate simply means if someone is performing a democratic function, then that someone should be democratically justified. If I am teaching you polity, I am fulfilling 3 conditions. 1, I am trained in the law. 2, I have been doing this for a sufficient number of years, so I am well aware of what the syllabus is. 3rd, I myself have had an exposure with the exam, so I know the pattern. If I did not have any of these 3, I don't have the right to teach you polity. Similarly, if your parents tell you what to do, it is because they take care of you. It is because they are your guardians. And therefore, similarly, if someone in a country, an institution, an office, a person is performing a democratic function, they better have the mandate for it. They better have the justification for it. If they don't, then they cannot perform that function. If they don't, then they don't have the right to perform that function. देश में बड़ा बड़ा डेमोक्रेटिक काम करना चाहते हो, पार्लियामेंट्री काम करना चाहते हो, खुद तो बताओ कौन हो? प्रेसिडेंट इलेक्ट करना चाहते हो, खुद इलेक्ट हुए थे क्या? सिंपल लॉजिक है. डेमोक्रेटिक फंक्शन इज व्हाट? इलेक्शन एंड लॉ मेकिंग. Anything which is a democratic process or a law making process, these are your two primary democratic functions. If you yourself are not elected, तो बात ही खत्म. Some mandate, that mandate may not necessarily be the best way. Depending on the function, your mandate can be light or strong, but होना चाहिए. नहीं है तो आप ये काम नहीं कर सकते. Now let us apply this rule to some real examples. ठीक है? For example, all of our bodies, constitutional bodies or statutory bodies, their recommendations are always recommendations. They are never binding. NHRC may be the most specialized human rights agency in the country. CAG may be the most specialized auditing agency in the country. At the end of the day, they're appointed institutions. Which is why anything that the CAG or the NHRC or any body will say will always be recommendatory in nature. Because they don't have the mandate to. If the government had to be bound by a CAG report or an NHRC report, then why the hell are you the government in the first place? Why did you work so hard? Understand a more primary example of this. We know directive principles are not enforceable in a court. What does that basically mean? It means if the government has not implemented a directive principle, you cannot go to a court of law and say, the government has not given me equal pay for equal work. They should have, it is in a directive principle. So, if directive principles were compulsory, they would take away the democratic mandate of the government. You have fought an election. You have won an election, you are in power, you decide policy. What is the point of you becoming a government if you are bound by some 10 lines that tell you what to do? Even all recommendations made by any parliamentary committee is still not binding on the parliament. No doubt, parliamentary committees have parliamentarians. But compare the mandate of the parliamentarians versus the mandate of the parliament. Who has a bigger mandate? The parliament. Why would a 500-member body compulsorily listen to 22 members? That would defeat the purpose of the majority. The answer to each of those questions is rule number 1. Why do you have to be an MP to be a minister at the center? Because the minister is going to be performing a democratic function. Tomorrow you are going to sit over a budget of thousands of crores and decide what is going to be the course of development in the sector that your ministry is involved in. You are not even a member of the parliament. Which is why you get 6 months. Chalo theek hai, you were too good, we needed to make you a minister. But at least by the next time the parliament sits, become an MP. Elected MP, nominated MP, Lok Sabha MP, Rajya Sabha MP doesn't matter. Because even if a Rajya Sabha MP becomes a minister, it is because the majority in the Lok Sabha wants that MP to become a minister. Remember, we discussed this yesterday. The only people who can decide who gets to be a minister are the people who have a majority in the Lok Sabha. who becomes a minister can be from either of the two houses. So at least we have tried to fulfill some democratic mandate. So even when we say that, for example, Jaishankar sir is the Honorable External Affairs Minister, he is a Rajya Sabha MP. You cannot turn around and say, अरे आप तो elected ही नहीं है, आप तो लोकसभा से ही नहीं आए हैं, मतलब लोअर हाउस से ही नहीं आए हैं. Jaishankar sir is the External Affairs Minister because the majority of the Lok Sabha wants him to be the minister. बात ही खत्म हो गई, मैंडेट है. एक बार हाउस में पहुंच गए तो मैंडेट जस्टिफाई हो गया. आप इलेक्टेड हो, आप नॉमिनेटेड हो, आप जस्टिफाई हो. विद इन द हाउस देयर कैन नॉट बी एनी डिस्क्रिमिनेशन. ये नहीं बोल सकते कि नॉमिनेटेड मेंबर्स मनी बिल पे वोट नहीं करेंगे. हाउस में है ना, बस. सो यू कैन क्रिएट दैट काइंड ऑफ अ सब डिविजन ऑल्सो. In a presidential election, only elected members will participate in the election to the president, elected of both the Lok Sabha and the Rajya Sabha, elected of legislative assemblies, and elected of Delhi and Pondicherry. Nominated members don't participate. जब खुद ही इलेक्ट होके नहीं आए हो तो आपको इतना बड़ा इलेक्टोरल में कैसे बिठा दे? The president has to be reflecting the will of the people. That's the case with Rajya Sabha also. The electoral college which elects the Rajya Sabha from that state has to necessarily be of elected MLAs. अब तो ये default ही हो गया है because all legislatures, lower ones, will only have elected. But back in the day, you had nominated also, pre-104th Amendment. Ordinance, we've heard of ordinances, Article 123 for Centre, 213 for states, though the numbers are not important. Why do the Council of Ministers get the power to draft an ordinance, take it to the President? Why does the President even get the power to issue the ordinance? Because both of them have some democratic mandate of some kind. And because it is a primary democratic function, ordinance is a law. A law can only be a law if it is passed by the legislatures, which is why ordinances are temporary. I understood that there was an urgency, there was something in national interest, you had to make an ordinance. Chalo, theek hai, given. But this cannot be a permanent affair. The only people in this country who can authorize the creation of an ordinance and then convert it into a final law which could exist in perpetuity, which could exist in permanence, is the legislature. And this is a very important principle. If there is a law, it has to be passed by the legislatures. Again, a factual correction in your standard textbooks. You've heard of the Appropriation Act in the budget, the Finance Act in the budget. In our standard textbooks, and Lakshmikant, for example, it is almost written that the Rajya Sabha doesn't vote on it. It's factually incorrect. No law can be passed at the center unless both the houses have voted on it, even if it is a formality of a vote. The Appropriation Act or the Finance Act, which is a part of the budget, is nothing but a money bill. Does the Rajya Sabha not vote on a money bill? They do. This is nothing but a money bill. They know that their vote is pointless. They know that anything that they will recommend can be overturned by the Lok Sabha if they feel like it. And even if they don't return it within 14 days, the Lok Sabha will override it. But do they not have the authority to vote? Yes. There cannot be a single law at the center which has not been passed by both the houses. It is invalid. Democratic mandate hai bhai.
तो राज्यसभा रखा किस लिए अगर वो कानून ही नहीं बना रहे हैं तो? दिस इज रूल नंबर 1. ऑर्डिनेंसेस, एमपी मिनिस्टर्स, हर जगह अप्लाई होता है. इलेक्शन प्रोसेसेस, रूल नंबर 1. नेवर फॉरगेट. क्लियर? In the sense that in a money bill, the Rajya Sabha can't reject it. The Rajya Sabha, let us say, makes an amendment to the money bill that can be overridden by the Lok Sabha. So, in a sense, Rajya Sabha knows that in something as sensitive as the budget, do you think the Rajya Sabha will ever make any recommendations in the budget? No. So, it is essentially a formal exercise. But it will still happen. Yes. The Rajya Sabha will formally vote on the appropriation bill and on the finance bill. It cannot become an act. It is a fact. So, अगर गलती से प्री में आ जाए कि that the Rajya Sabha doesn't vote on the appropriation bill, that is actually incorrect. ये रटने की जरूरत ही नहीं है. It's simple logic. A law can only be a law if it is passed by the legislatures concerned. So even at the states, those few states which have a legislative council, it has to be passed by both the houses. Though the assembly can override the council with every law. Every law in the states which have two houses, the assembly can override it on every law. But they will still have to pass it. तो बनाया ही किस लिए? The whole point of a legislature is, the primary function is to make laws. If a legislature is not making a law, then you are failing the democratic mandate. So rule number 1 exhaustively applies on so many different cases. ठीक है? Clear?
Sir, president के पास भी
Because it's a very good question.
Then why he is binding on council?
बता रहा हूं ना. The president has been elected with a democratic mandate. Members from the state and the center have chosen the president, which is why the president in his name and capacity can issue an ordinance, can declare an emergency, can shut down a state legislature in the case of Article 356. But if the president singularly could do this on your own, then what is the point of parliamentary form of government? This is why, while the president can never be on your own, because that would violate the essence of parliamentary democracy. पहले तो parliamentary democracy है, फिर parliamentary mandate है ना. That is why.
Sir, at the floor of house, every MP is
equal.
Then why nominated one are not electing the president?
Because this is an electoral function. His question is also a very good one. बहुत अच्छा question पूछा है कि सिर्फ on the floor of the house every MP is equal, no matter who they are, then why are they not electing the president? Because it's an electoral function.
They do not show the true democratic mandate.
It is an electoral function. An electoral function is a separate kind of a democratic function. Now think about it. A nominated MP will also vote on a no confidence motion. Yes? House mein na? Within the four walls of the house. Anything which happens within the four walls of the house affects the house. Everybody is equal. President doesn't sit in the four walls of the house, no? This is why. No confidence, censure, money bill, adjournment, sab mein sab vote kare. Resolution, private member, sub. Another factual correction. Democratic mandate. We know that either you are an MP on a party ticket, you've been elected on a party ticket, or you are nominated, और यूर एन इंडिपेंडेंट एमपी, खुद से अकेले जीत के आए ना, यूर अ मेंबर ऑफ द पार्लियामेंट. How the hell can I stop you from introducing any bill you want to? Except the budget, of course. Because the budget is a proposal of the government. So can a private member introduce a money bill? Yes. Financial bill? Yes. Ordinary bill? Yes. Constitutional amendment bill? Yes. Yes. There's nothing that can stop an MP from introducing any bill except a budget, because a budget is a governmental proposition. Budget is government coming to you and saying, मेरे पास इतना पैसा है, मैं इससे खर्च करेगा. उसमें तो प्राइवेट एमपी का कोई रोल ही नहीं है. Several examples. Today we are discussing the preamble. The amendment to the preamble which was proposed the year before last was by a private member. An amendment to Article 21 to introduce right to health was by a private member. These are factual evidences. Private members can introduce a money bill. क्यों? अरे आपकी पार्लियामेंट है, आपको लगता है सरकार को यहां खर्च करना चाहिए तो करो ना बिल इंट्रोड्यूस. It is factually incorrect to say that a private member of parliament cannot introduce a money bill or a constitutional amendment bill or a finance bill. क्यों नहीं करेंगे भाई? करेंगे, हम मेंबर हैं. तो क्या हुआ सरकार हमारे साथ नहीं है? तो क्या हुआ हम मेजॉरिटी नहीं है? I am as much a part of the house as a member of the current government. कोई फर्क नहीं हो सकता within the four walls of the house. You are violating the privilege of the house. Everybody will vote. Because when you are violating a privilege of the house and I am a member of the house, I get to have a say in the privilege. Yes? फिर तो अब ये नहीं कह सकते कि why are nominated members voting on privilege issues? Because you are violating the integrity of the house. I am the house. How did you stop me from doing it? Once you're on the floor of the house, nominated, elected, independent, private, public, government, all members are the same. Except the budget, because the budget is a governmental policy. आप नहीं रोक सकते. Clear? Yes. Understood? Rule number 1. Please. No, the governor is appointed. I'll come to rule number 2, you'll understand why. The governor has been appointed by the president on the advice of the council of ministers. So there's an implied mandate. And governor is always looked at not only from rule number 1, but rule number 2 also. अब देखना कैसे? ये clear है? So if in the pre you get a question, the members of the electoral college electing the president are so and so. कई बार क्या होगा? मेमोरी फेल कर जाएगी, थोड़े से ब्लैंक हो जाएंगे. Then go back, apply these rules. बना बनाया क्वेश्चन हाथ में आएगा. These rules are informal rules, but ये नंबर दिला देते. अपने को क्या चाहिए? Rule number 2. Please.
So, also if nominated members participate in electoral college of president, it could be violation of principles of natural justice because they are nominated by president also. So,
Yeah, but it is not an administrative process, but yes, by extension you could say so.
and so in democratic mandate, we can conclude that elected representatives have democratic mandate with direct election.
Yes.
Greater than.
Yes, fantastic, very good. Good argument, both of those. चलिए, फेडरल बैलेंस, इसको समझाने का एक बहुत सिंपल तरीका है. ठीक है? How many of you have younger siblings? So the rest of you, so the people who have raised their hands are elder siblings. The rest of you do not exist. We as elder siblings have a fundamental right, guaranteed also under the Universal Declaration of Human Rights, to violate the very existence of younger siblings. This elder younger sibling is also center in states, which is why we have a written constitution and all of those things to divide those powers, for this simple reason. Center आपका elder sibling है, state आपका younger sibling. So the second rule has 3 stages. Stage number 1, यदा यदा ही धर्मस्य, नहीं, यदा यदा ही center states overpower या see. The first instance is the center will overrule the states. Whenever the center will have a superior power over the states, will override the states, एकदम से हमारी घंटी बजेगी कि यार कुछ हो रहा है. If this is happening, then the states will be given something to be pacified with. कि बुरा मत मानो, होली है. And just when the states start feeling good, they will realize that the pacification or the appeasement was hollow. छोटे भाई बहन को कैंडी देते हैं, पहले तो कूटते हैं, फिर 5 स्टार देते हैं, वो 5 स्टार खोलता है, उसमें कीड़ा होता है. यही है सेंटर स्टेट. Whenever the center will have a stronger position than the states, we will try to give the states some decency, some way to save their face, but it would really not mean anything. Ultimately, the center will have an upper hand if the center needs to. There are far too many examples of this. Let's start with the most basic ones. आज पढ़ेंगे immediately after this. Any territorial change the parliament does. You want to cut UP into Uttarakhand, you want to create a Jharkhand, you want to create a Chhattisgarh. Who decides? Center. Ultimately, the impact is on the state, na? But the territorial boundary of a state is decided by the parliament. This is the center stronger than the states? Yes. So therefore the parliament is going to be making a law for it. States को बुरा लगा कि ऐसे करें. Then we will tell the states, don't worry. Before we introduce the bill, a guy that you have chosen also, president, will refer it to your legislature. President will refer a reorganization bill to the state. कि बताओ यूपी को काटे कि नहीं. States get very happy. मेरे को पूछा. And just when they are getting to debate and ready and they are saying हाँ नहीं करना चाहिए, president ने फोन ही काट दिया. Because the law says you have to ask. It doesn't say you have to listen. Reality of life. You have to show concern, not hear concern. बस यही है rule number 2. You want the parliament to make a law on something which is in the state list. मतलब एक तो तुम्हारे यूनियन में हमसे ज्यादा पावर. You have around 100 subjects, right? 97, 96, 97. Okay, great. कभी नहीं पूछेंगे एग्जाम. 97 subjects. States ने कितना 66. अब नहीं पता है. I think 66, right? And 47, I think, in concurrent. Say. The union list has the largest number of subjects. मतलब अपना तो तुम 99 में कर ही रहे हो, 97 में कर ही रहे हो, उधर कॉन्करेंट में भी कर रहे हो 47 में. अब मेरी छाती से 66 भी लेके जाओगे. So then what does the law tell you? आपने जो लोग बिठाए ना यहां, किसको? राज्यसभा. जब तक राज्यसभा परमिशन नहीं देगा हम नहीं कर सकते. हाँ, स्टेट. गुड पॉइंट, ग्रेट पॉइंट. So unless the Rajya Sabha authorizes the center, unless the Rajya Sabha authorizes the parliament cannot legislate on something which is in the state list. Yes, यही तो था ना special majority 1. More than 2/3 of present and voting. States are very happy. But after the Rajya Sabha has passed a resolution, ultimately both the houses will decide. And who has more numbers? Lok Sabha. Yes? And what if the party who has majority in the Lok Sabha also has majority in the states? Then Rajya Sabha becomes Lok Sabha 2.0. फिर क्या करोगी? There is nothing bigger than a sham called federalism. Ambedkar sir was a smart fellow. ऐसा चिपकाया है ना हमारे देश में. Because we needed that unitary bias. खेल पूरा unitary bias का है. Supreme Court judge is appointed by a collegium. High Court judge is appointed by a collegium. Collegium तो nationally बैठता है. Yes. States का मूत्रा. फिर हमने क्या कहा? Don't worry. No. When we are making a collegium for High Court judges, we will ask your government, but we will keep the phone down. And you have the powers to make your own rules. और ज्यादा बुरा लग रहा है तो इलेक्शन पिटिशंस कैन ओनली बी फाइल्ड इन द हाई कोर्ट. स्टेट्स आर लाइक सच्ची. इवन an election petition for a Lok Sabha election can only be filed in the High Court. Yes. क्या हुआ? सब ठीक? ओके. अरे क्या है? सही बात है. अरे तू सवाल मेरे से पूछ लेना. कोई बात. अरे कोई बात. अरे मेरे से गलती हो. कोई बात नहीं. अच्छा ठीक. I have heard you. And now I will apply rule number 2. सुना मैंने. डोंट वरी. कुछ डाउट मेरे को आराम से पूछ लेना, मैं आराम से घर आके समझाएगा तेरे. टेंशन मत बस. Because this is a very intense class. Every word that I say is very important. So you have to be very focused here. है ना? जो डाउट है लिख ले, या तो पूछ ले हाथ खड़ा करके, या बाद में पूछ ले. है ना? कलेक्टिव DPSP फंडामेंटल ड्यूटी, कलेक्टिव हार्मनी. Anyway. So that is the case. Election petitions can only be filed in the High Court. States get very happy. What they don't realize is so that the Supreme Court is not burdened. हर जगह है. you will see center stronger than states in every possible organ of government. The parliament can make a law to implement an international agreement. राज्यसभा को ऑथराइजेशन चाहिए या नहीं चाहिए. If the parliament, if we have to implement an international agreement, we can't wait for the Rajya Sabha. We can't. Yes or no?
Yes, sir.
If the parliament has to make a law because the executive has signed an international agreement, the Rajya Sabha doesn't need to pass a resolution. वो करना पड़ेगा. अब क्या करें? सिंबॉलिक स्टेट्स ने बोला ठीक है, कल आप कुछ भी साइन करके आओगे, हमको बेचना पड़ जाएगा सब कुछ. Who is the head of state? President. Who signs international agreements? President. And who elects the president? Center and states. इसमें याद क्या करते हो? Simple, clear-cut logic. I'll come to the question the maroon shirt gentleman had asked. आपका question अब ध्यान से सुनो. In a presidential election, elected members participate. Yes. But in the removal of the president, everybody participates. ये कहां की fairness है? Yes or no? In the election to the president, the center and the states participate. But in the impeachment of the president, only the center participates. States को नहीं देते participate करने का मौका. That itself is rule number 2. The states can ask, you asked us when you were electing the president. Now if you want to remove the president, you will not ask us. The candy is, because we've asked you to elect the president, now we can afford to not ask you to remove the president. That doesn't mean you don't have a say. Because your representatives are sitting in the center. Who are they called? Rajya Sabha. तो आपके नुमाइंदों से पूछ रहा हूं ना मैं. फिर and because you have participated in the election to the president therefore is justified in the powers to impose the emergency in your state. आपने चुना ना प्रेसिडेंट को, अब प्रेसिडेंट आपका लेजिस्लेचर बंद कर सकता है अंडर 356 क्योंकि आपने मैंडेट दिया है. एंड इफ आई हैड गिवन यू द अपॉर्चुनिटी to impeach the president, every time the president imposed emergency in state A, state B would start impeachment. कुछ तो हमको सेंटर को बैलेंस रखना है ना, बस. Now comes the second question. Why do nominated members participate in the removal but not in the election? Because the grounds for removal is violation of the Constitution. The grounds are not political. It is a quasi-judicial process. Within a house, everyone is equal. Isliye. You are not removing the president for a lack of mandate. You are removing a president for violation of the Constitution. Isliye. गवर्नर आपने अपॉइंट किया. यस, गवर्नर इज नथिंग बट लोकल प्रेसिडेंट फॉर द स्टेट्स. स्टेट्स का मुंह नहीं उतरेगा कि ये क्या है. इमेजिन वी आर हैविंग लाइक अ पोस्ट इंडिपेंडेंस आफ्टर पार्टी इन राष्ट्रपति भवन. डीजे माउंट बैटन इज प्लेइंग चन्ना मेरिया चन्ना मेरिया. नेहरू जी थोड़ा गम में बिकॉज FDI is going out. Yes? फिर अंबेडकर जी बोले नेहरू जी को, चलो बात करनी है सबसे, चलो. So all states come together. नेहरू जी बोले ये हम प्रेसिडेंट राजेंद्र प्रसाद जी, स्टेट्स ने कहा नमस्ते, एक रिटर्न गिफ्ट लेके जाना है आपको, आप सबके लिए एक एक गवर्नर. वी विल अपॉइंट द गवर्नर थ्रू द प्रेसिडेंट. स्टेट्स लाइक अरे हम तो चिल करने आए थे, ये क्या है? The institution of the governor is an anti-federal institution. On advice of the Council of Ministers, the president is appointing the governor. Yes? तो कुछ कैंडी देना पड़ेगा ना, ओली करने के लिए. Number one, that is why we've developed a parliamentary convention or a constitutional convention. That if you're appointing the governor, ask the CM. But don't listen to the CM. यही है. And number two, constitutionally the governor has more powers of discretion than the president. States के आंखों में आंसू आ गया कि मेरे वाले के पास तेरे वाले से ज्यादा पावर है. Because the president has no constitutional discretion. There is nothing the president can do on his own. Nothing. Zero. Constitutionally. जो situational discretion है कि मैं mandate ही नहीं था. So when the president gets to decide कि अच्छा majority clear नहीं, आप सरकार बना लो, because there is no democratic mandate to bind the president. But अगर गलती से mandate है, the president cannot use his or her mind. Governor can. Any bill in the legislature of the state, the governor thinks ये साहब के पास भेजना है, वो जाएगा. Yes or no? Yes. So even if the governor has more discretion than the president, the discretion is in favor of whom? Center or states? कटा ना बस. Yes. नहीं, बजट नहीं भेज सकते. प्रोरोग करेगा, हमें पता था अभी पार्लियामेंट्री सेशंस में. हाँ, तो प्रोरोगेशन का जो प्रोसेस है ना, कि प्रोरोग कैसे करते हैं, इट्स नेवर द गवर्नर और द प्रेसिडेंट. लाइक एट द सेंटर देयर इज द मिनिस्ट्री ऑफ पार्लियामेंट्री अफेयर्स which will work in coordination with the cabinet committee on parliamentary affairs, who will then recommend कि अच्छा आप बंद करो. ये अपने मन से नहीं करते.
बजट ऑफ स्टेट सर,
किसी का भी सेंटर स्टेट तो मैं पैरेलली बता रहा हूं ना, जो सेंटर में वैसे ही स्टेट्स में. ये बहुत बड़ा मिथ है that the president is proroguing the house on their own. नहीं, सब कुछ डेमोक्रेटिक मैंडेट भाई. रेसोल्यूशन बताया था यार मैंने, रुक जा, बात तो है ना कि ऑटोमेटिक होता है, नहीं होता है तो फिर कैसे है. I'll tell you. ठीक है, क्लियर, सिंपल है. नाउ कम्स रूल नंबर 3 and 4. ये तो और भी आसान है. रूल नंबर 3 and 4 have two sub rules within themselves. Two simple sub rules within themselves. इसको ऐसे समझते हैं, स्कूल गए थे तभी यहां है. वी हैड इंटर स्कूल कॉम्पिटिशंस, रिमेंबर, स्कूल 1 वर्सेस स्कूल 2 वर्सेस स्कूल 3, एंड वी हैड इंटर हाउस कॉम्पिटिशंस, रेड हाउस वर्सेस येलो हाउस वर्सेस ग्रीन, कुछ ऐसे, गांधी हाउस वर्सेस नेहरू हाउस, which now today you realize the fun behind it, कि गांधी वर्सेस नेहरू इन कबड्डी. वो तो अब जाके आपने पढ़ा, ओ है ना, था ना, गांधी हाउस वर्सेस नेहरू हाउस वर्सेस शास्त्री हाउस वर्सेस शिवाजी हाउस. जो हिस्टोरिकली थोड़ा इनअप्रोप्रिएट था, क्योंकि वो टाइमलाइन में मैच नहीं कर रहा था। लेकिन तब हम में अकल नहीं थी क्वेश्चन करने की कि गांधी, शास्त्री, नेहरू तो समझ में आ रहा है, ये शिवाजी थोड़ा लेट नहीं आए हैं। यस, तब हमने क्वेश्चन नहीं करा। सो इंटर हाउस कॉम्पिटिशंस आर नथिंग बट इंट्रा स्कूल कॉम्पिटिशंस। यस, ठीक। देयर आर 3 organs of state: ब्रह्मा, विष्णु, महेश, लेजिस्लेचर, एग्जीक्यूटिव, जुडिशरी। अब इसको ध्यान से समझना। इंटर मतलब L, E और J, इंस्टीट्यूशनली। इंट्रा मतलब इनसाइड L, इनसाइड E, इनसाइड J. So what is inside L? Lok Sabha, Rajya Sabha at the center, for example. Elected executive, permanent executive inside the E. Supreme Court, High Court, etc. inside J. So inter-separation of powers means L, E and J as much as possible have to be separate from each other. ज्यादा भी खुला नहीं छोड़ सकते, because these are the 3 power centers. Separation of powers है तो checks and balances है. Checks and balances is a natural corollary of separation of powers. You've kept them separate so that you can keep a check on each other. So inter-separation of powers automatically means inter-checks and balances. So L, E and J separate from one another. L, E and J keeping a check on one another. Inter-checks and balances. Inside L, inside E, inside J. So keeping a separation internally in the legislature, intra-separation of powers. And internally, they keeping a check on each other, intra-checks and balances. Clear? This solves the rest of your polity. The conduct of judges cannot be discussed on the floor of the house, and the conduct of parliamentarians cannot be discussed in a court. लिखा है ना clearly? Yes. क्या है ये? Inter-separation of powers. Judiciary is a self-appointed mechanism, higher judiciary. Inter-separation of powers. But judges of the Supreme Court and the High Court can be removed by the legislature. Inter-checks and balances. Unless, देखो, तीनों का अपना अपना गेम है. तीनों का अपना अपना गेम है. Legislature has a mandate. The executive also has a political mandate. And the judiciary has a legal mandate. तीनों अपना 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 कर रहे हैं. बस एक ही है साधु आदमी. There is only one person जो दुनिया की मोह माया से ऊपर है, जिसको कोई फर्क नहीं पड़ता कि धन, दौलत, खुशी, दुख, पैसा, कोई फर्क नहीं पड़ता. लीगली there is one person who is to be legally apolitical. कौन है वो? President. So in सबकी interactions will always be through the president. Always. Under ordinary circumstances, the Lok Sabha and the Rajya Sabha can never sit separately, can never sit together. Yes? Joint session तभी होगा जब प्रेसिडेंट बोलेगा. अगर इन्हीं पे छोड़ दोगे तो जब भी करा लेंगे. Yes? Why does the president formally dissolve or prorogue? Because अगर स्पीकर पे छोड़ देते तो कभी डिसॉल्व ही नहीं होता. अभी तक नेहरू जी की आत्मा होती लोकसभा में? यस, बट व्हाई डज द स्पीकर adjourn? इंट्रा सेपरेशन ऑफ पावर्स. एंटी डिफेक्शन स्पीकर डिसाइड करता है. All other disqualifications precedent. It's nothing but an application of separation of powers. Because anti-defection is for defection. And defection affects the majority of the house. And majority of the house is within the house. And who's the godfather of the house? Speaker. Simple. अब याद क्या करोगे इसमें? Understood? Questions of disqualification and anti-defection, speaker decides. Why? Because of intra-separation of powers. But disqualification under constitutional provisions or representation of People's Act, President decides. Clear? Intra. Separation of powers, checks and balances. एक second. Now, the elected executive will always be superior to permanent executive because of rule number 1 applied with rule number 4. भाई ये elected है, but the permanent executive must also keep a check on the elected executive. Yes, but ये normal बन के आएंगे तो इनके चिथड़े हो जाएंगे, तो इनको अवेंजर बनना पड़ेगा. यस, ताकतें देनी पड़ेंगी कि तुम करो संघर्ष, तुम बोलो कि सरकार ने पैसा ठीक से खर्च नहीं किया. आप बोलोगे कि वो निकाल देंगे बाहर, सैलरी कम करते, तुम्हें खाना कैसे खाएगा? डोंट वरी, I will protect you. I will constitutionally give some of you additional protections. And you will be called constitutional bodies. Constitutional bodies are constitutional bodies because they have been given the constitutional protection to question the elected executive. लेकिन सीधा नहीं पूछ सकते, सीधा नहीं पूछ सकते, because where is the final democratic mandate? Which is why reports of these are showed up here through the president via some parliamentary committees. It's nothing but a function of checks and balances. The elected executive never examines a report of a body because उन्हीं पे report है. Checks and balances, legislature keeps a check on the executive. तो बुलाओ जरा इसको, CAG को बुलाओ, पब्लिक अकाउंट्स कमेटी के सामने बिठाओ, बोलो कितना पैसा खर्च किया, हम देखते, हम पूछेंगे. बस. Your entire polity runs on these 4 rules. तो कभी ना प्री में ऐसे रैंडम क्वेश्चंस आते हैं, दैट पेट्रोलियम रेगुलेटरी गैस बोर्ड. यस, इफ एन इंस्टीट्यूशन इज अ रेगुलेटरी इंस्टीट्यूशन, इट हैज टू बी बैक्ड बाय लॉ, रूल ऑफ लॉ, सिंपल प्रिंसिपल. ऑप्शन में लिखा होगा इट्स अ एग्जीक्यूटिव बॉडी, अपने आप गलत. एवरी रेगुलेटरी बॉडी will have to be backed by law. नहीं तो पावर ही नहीं है रेगुलेट करने की, कहां से आ जाएगी? Simple principles. You want to regulate a sector, the lawmakers have given you the power to do so. और जो थोड़े से शेडी ग्रे एरियाज हैं, उनको हम BCCI कहते हैं. बस हो गया. आप कुछ पूछ रहे थे, सॉरी. हाँ, ध्यान से सुन, राहुल गांधी की बात कर रहे हैं ना हम। अंडर व्हाट लॉ हैज ही बीन डिस्क्वालिफाइड? रिप्रेजेंटेशन ऑफ पीपल्स एक्ट। बट किया क्या? किस क्राइम पे कन्विक्शन हुई? सेक्शन 499 ऑफ द इंडियन पीनल कोड मेक्स डेफमेशन अ क्रिमिनल ऑफेंस। कल बता रहा था मैं। सो राहुल गांधी जी हैज बीन कन्विक्टेड फॉर क्रिमिनल डेफमेशन। यहां तक क्लियर है? ठीक। लिली थॉमस के पहले था, जब तक फाइनल कन्विक्शन नहीं होता, मतलब द हाईएस्ट कोर्ट, तब तक यू कैन कंटिन्यू। लिली थॉमस के जजमेंट में सुप्रीम कोर्ट ने कहा, इवन इफ द लोएस्ट कोर्ट हैज कन्विक्टेड यू फॉर अ मिनिमम नंबर ऑफ दोज ईयर्स, आपका टाइम हो गया एंड यू आर बैंड फॉर 6 years। ठीक है, कोर्ट ने कन्विक्ट कर दिया। अब किसी को तो लिखोगे ना, इफ आई हैव कन्विक्टेड राहुल गांधी इन अ क्रिमिनल कोर्ट इन गुजरात, दैट हैज टू बी, उससे क्या हुआ? सीट चली गई ना फ्रॉम द डेट ऑफ कन्विक्शन। तो चिट्ठी लिखोगे ना लोकसभा सेक्रेटेरिएट को, तो वो पब्लिश करेगा ना चिट्ठी, बस। क्योंकि कोर्ट ने डिस्क्वालीफाई कर दिया तो वो ऑटोमेटिकली डिस्क्वालीफाई हो गया, कुछ कर नहीं सकते उसमें। एंड बिकॉज द डिस्क्वालिफिकेशन हैज टू फाइनली बी साइंड बाय द प्रेसिडेंट, तो प्रेसिडेंट ने भी साइन कर दिया, उसमें अपनी अकल थोड़ी लगी। तो कानून है, रूल ऑफ लॉ। एक सेकेंड, द प्रॉब्लम इज वी हैव अ टेंडेंसी टू ओवर कॉम्प्लिकेट सिंपल शिट। हम परेशान हो जाते हैं, करना नहीं है ना? आप कुछ कह रहे थे? सिक्स। अच्छा, मतलब ओके, फॉर 2, मतलब आप कह रहे हो कि इंस्टेड ऑफ 2 years ऑफ जेल उसको 200 दिन जेल भेजा? हाँ, नहीं नहीं, अगर आपको कम से कम 2 साल की जेल होगी तो रिग्रेस, तो आप एमपी नहीं बन सकते। यही है ना कानून, बस। If the High Court turns the conviction, then he will be back being an MP. ये परेशान क्यों? ठीक है, डन। 4 रूल्स क्लियर हो गए? यस। रूल नंबर 1 क्या है? डेमोक्रेटिक मैंडेट। रूल नंबर 2 क्या है? फेडरल बैलेंस। रूल नंबर 3 सेपरेशन ऑफ पावर्स। रूल नंबर 4 चेक्स एंड बैलेंसेस। ये तो हमारे एकेडमिक रूल्स हो गए। कल हमने नॉन एकेडमिक अप्रोचेस डिस्कस करे थे। सबसे पहला यूपीएससी लैंग्वेज अकॉर्डिंग टू द कॉन्स्टिट्यूशन। दूसरा ऑप्शन को सिंप्लीफाई। तीसरा क्वेश्चन द क्वेश्चन। ये याद है? ये क्लियर है? रूल ऑफ लॉ क्लियर है? प्रिंसिपल्स ऑफ नेचुरल जस्टिस क्लियर है? आर 4 रूल्स आर क्लियर। अब देखते पॉलिटी कैसे लिखती। ठीक है, डन।